Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Listen, first of all, let me apologize for being so darn late with the footage. Those that are in the membership, I went live last night at about midnight to explain that, honey, this footage was so long. It was 2 hours that it took a while to get it downloaded and then to be able to get it transferred to me and all of that good stuff. So it was so late that I did not want to go live that late. And shoot, I had to take 3 naps just to try to stay up yesterday to do it. And then I couldn't do it anyway. But I am here today with the footage that you all have been waiting on. We have some great footage of this hearing, of which you will feel like you were in the courtroom yesterday. I have not watched it yet. We watched about 15 minutes last night when it got delivered to me. I put it on because we were live in the membership, and so everyone saw the first 15 minutes. However, no one has saw the testimony yet or anything else. And again, this is 2 hours. So what I suggest is, if you're trying to watch this whole 2 hours, get your snacks together, put in your ear pods or whatever you need to do so that you won't miss a beat. From my understanding, there is arrest footage and all type of stuff that was going on, but I am going to see it for the first time. If I feel like my facial expression needs to be seen, and I put the camera on and just, I look real, like I'm getting over something. That's what I look like. But nonetheless, I feel a lot better. So thank you guys so much for all of the well wishes. I appreciate that. Thank you so much for gifting 5 memberships. I appreciate the support. Make sure as you come in, hit the like button. My girl Stacy, thank you so much for looking out. At this point, my videographer knows about everybody because he's been there enough. And he said that our girl Stacy looked out for him. So I appreciate that. And then also it was funny because when he came in, it was about 9:20 when he started setting up. He was like, yeah, Sonia's here. I said, this is funny. He knows who everybody is that are players in this here game. It was like, she's over here in the back row. Your girl Stacy's right here. So and so is right here. Somebody else just came in. They just set up a camp. Like, I knew everything that was going on until his phone died, because I was trying to give updates on what was happening in the courtroom, at least in the membership, but his phone died. So then I couldn't give any updates. So I'm not going to talk too much. Hello to everyone. Welcome. If you're new, welcome back. If you've been here before, please make sure you hit the like and subscribe button so we can get up in this algorithm. Shay B, I appreciate it. Thank you so much for the super chat. I appreciate it so much. Thank you for supporting the platform. All the love is felt for sure. We're going to get into it because it's going to take us a little minute to get through this. And again, I'm going to be watching a lot of this for the first time, because once I got it last night at midnight, we did the first 15 minutes and then I took myself to bed. Okay. Thank you again for y'all showing out today. Thank you so much for gifting the 5 memberships. I appreciate that. You said you got the dark roast. You ready? Y'all better get ready now. Get your notes and all of that, because apparently for 2 hours they had some talking to do. And I'm going to stop once they do the intro, kind of how I did in the membership, when Wooten talks and then Hoover responds. I'm going to explain what is going on and what this hearing is actually about and what is going on. Okay, so I'm going to do that. But when the video comes on, I'm going to try my best not to stop in between so you guys can get a full recitation of the video. Thank you so much. I appreciate that, India, not in India, not India. Is that what that's saying? Thank you so much for the super chat, honey. I appreciate that. Traveling Tootie said, I got my notepad. All right. Okay, let me get to when we first get started. As y'all see, there goes your boy Nesto, and there goes Hoover right there. That's my videographer talking all in the camera and stuff.
And then
Let me go back a little bit. Trying to make sure.
All right, let's take up Mr. Earnest Williams, 24 SC 001723. Mr. Williams is in court. Good morning, Mr. Williams. All right, we are here on, there are a number of motions that have been filed. I understand there might be some disagreement as to what we need to take up today, but I show that there is a general demur that's been filed, state's notice of introducing intrinsic evidence, and then a motion to suppress vehicle search. 8A Wooten, what do you have this morning?
Judge, the intrinsic evidence, we had done a hearing on that a couple months ago, so I think that's resolved.
Okay.
I spoke with Mr. Hoover this morning, and I don't think that there's any need for argument on the demur. I think we're both submitting that on the briefs.
All right.
As it relates to the motion to suppress, there's kind of two issues that have come up. The first is, yesterday afternoon, about 4 o'clock, I received an email from Mr. Hoover that basically said that he intended to challenge, in addition to what's in the written motion to suppress, which is limited to just the search of one vehicle and one search warrant, that he also intended to challenge an arrest warrant that was issued on May 10th, 2021, more than a year prior to the search of the vehicle, as well as 2 residential search warrants that were issued the day of the search of the vehicle. And so the first issue is, our position is that the challenges to the arrest warrant and the 2 residential search warrants are way outside the scope of what's in the written motion. The court requires particularization. There's nothing in the written motion about those, and so we were not put on notice that those are being challenged, and they require different evidence, different legal arguments, and we're just not prepared to go forward on those. We're also well past the motions deadline in the case, so the state's position is challenges to those things that are outside of what's in the written motion should not be taken up by the court. So certainly not today, and likely not at all, because we're past the motions deadline. So that's kind of the first issue. The second issue is related to the motion to suppress the vehicle search itself, which is, it's the state's position, and we filed a written response to the motion, that there's nothing that was seized from the vehicle that's part of this case. Mr. Williams has other pending matters, some pretty serious charges. Evidence related to those charges did somewhat come from the search of the truck, but those charges have not yet been indicted. And so it's the state's position that really what's going on here is an attempt to kind of pre-suppress some evidence that's related to a case that's not yet indicted. I've asked Mr. Hoover multiple times to tell me what evidence have I turned over in discovery that came from this truck. I made that request in open court, I believe in September. We met also in October, I made that request, and then in my written response to the motion, I made that same request. And still to this day, I don't know what evidence we're talking about. Based on my understanding of all the evidence and where the evidence that I've turned over came from, if I can get an understanding of what exactly is at issue, I think there's a significant possibility that I can stipulate that that evidence will not be admitted in this trial, because I don't think it has anything to do with this trial. So I guess the two things, the first thing is the issues that came up yesterday via email, I think that we're not on those for those. And then as it relates to the vehicle search, I just would like to know what exact evidence we're talking about, because I think we can save the court time. And I think that these issues just aren't right in this case. I think that they may be right at the time that the other charges are indicted, but they really don't have anything to do with this case before the court today.
So,
Okay, yeah, I think I need to interject right here because Wooten just talked. First of all, Mr. Wooten, I need you to put your face to the mic. That's all I'm saying. Put your mouth to the microphone so that we can hear you a little bit better. But nonetheless, what he was arguing was at first, apparently last night, Mr. Hoover added additional warrants that he wanted to suppress. That's what he's alleging. So it was like an arrest warrant, the warrants that came out to search warrants for the home, all of those. When the initial motion only mentioned the certain warrants, like one or two different warrants, and now he's added more last night of what he wanted to talk about. So he was like, he doesn't think this is the proper time for that because that was outside of the scope of what his motion was about. So that was one of the first things he was arguing about. Remember, he also filed what's called a demurrer motion where he was trying to get rid of the RICO account. They said they don't need to argue that here. They'll just let the judge do it on the pleading. So they're not asking for oral arguments on that. So that wasn't anything that was going to happen on yesterday. And then Wooten, remember, he filed a response to the motion to suppress and basically said, look, you may have some issues with these search warrants, but I got independent evidence outside of the search warrants. I'm not using anything that is a product of these search warrants. So I don't think we should even really be doing this evidentiary hearing, because what information are you alleging I obtained that is that's derived from these search warrants? What evidence are you saying that I obtained that has something to do with this case that should be suppressed? Now, he does have unindicted situations, and that what was in the car, such as the laptop and all of that may have something to do with those cases, but that don't have nothing to do with mine. So I feel like we could save the court's time if we know exactly what he's trying to suppress, because I might be able to stipulate it, because he's basically saying anything happened from the car, those search warrants, I don't need it anyway to prosecute him, is really what he's saying. So then now, as you see, he's sitting down, and now Hoover, who is Williams' attorney, is about to respond right now. So we're going to listen to what his response is.
I guess let me hear from Mr. Hoover, and I'll come back.
Yes, Your Honor, thank you. So I agree with the state that we already did argue the intrinsic evidence motion which way in the ruling. I also agree with the state we talked about this morning that we're going to let the briefs for the juror just stand on that. That's pretty much it where I agree with the state. In regards to the motion to suppress, number one, the state's response that it's not right and it's rude. First, the cases they quoted don't even really apply to the argument that they're trying to make. But number two, Mr. Wooten, maybe he just expressed it differently. I never said that I was attacking the search warrant. The email I sent to Mr. Wooten was these are the warrants we're focusing on. So there was an arrest warrant that led to a search, and that search led to these other warrants. So I'm not attacking the arrest warrant. I know the arrest warrant was a pending arrest warrant. What I said was these are the ones I'm focusing on because I have to show the court the chain as to where we're going. Now, in regards to what evidence we're talking about, Your Honor, all of the evidence in this case came from this illegal search. I've told Mr. Wooten, I don't know how many times, everything. I'm not particularizing 3 cell phones, 1 laptop, a hard drive, everything. Because what we're saying is, based off of the warrant, this illegal search happened. Based off this illegal search, they got all these other warrants to do all these other searches to get all this evidence. Because this was flawed, because this tree was poisoned, everything else that they got because of the poisonous tree goes away too. I don't know how to make that, I'm sorry, I'm not making it any clearer unless I give them an itemized list of every single piece of evidence they turned over to us. But what we're saying is, I will be focusing on all of these warrants to show the court there is a chain to why everything they collected in this case and everything they collected in the other cases indicted should be suppressed, because it all started with this constitutional violation of that search.
And I read your motion.
Okay. So what Hoover is arguing, he said he agrees that with the demur that we'll just do it on the pleadings, but that's all he agrees with Wooten on. He does not agree with how he's characterizing what occurred with his email the night before. What he is saying is he is not arguing about the arrest warrant. There was a pending arrest warrant, but after the arrest warrant, it became a search warrant. And after the search warrant occurred, he's saying that search warrant was done illegally, right? That search was done illegally. So when you have one search that's illegal, he said, then after they searched, say they searched the vehicle, they found other things that led to them being able to execute other search warrants. But it all originated from this original search warrant. And because this original search warrant was not done properly, that's called fruit of the poisonous tree, where everything that comes thereafter should also be suppressed. So if the way that you initially got this information was not correct, then everything that you've got that can be somehow connected to the first warrant, that all of that stuff should be suppressed and it should not be considered. So that's what he's arguing. He's like, it's not about a laptop. It's not about a phone. He's saying everything. So what he is really arguing is all the information that the state has gotten on Ernest Williams all came from this original search warrant. Everything. So he was arrested. He had an arrest warrant that was pending. Remember, they had been watching him for a little while. He gets arrested, and then they execute this search warrant. But the way they execute the first search warrant was not adequate. So it sounds like, and we'll get into what the first warrant was about, but they're saying it was not, it was unconstitutional is what they're saying. And he's saying everything. So he is not agreeing with Wooten that you got some type of independent sources. He's saying that somehow he's able to connect all your evidence that you've gotten against his client from this original warrant that should have never been executed in the first place. And I mean the search warrant. He's not arguing about the arrest because the arrest warrant was already executed. It had nothing to do with whatever. He's saying that specific to these searches.
According to your motion, the vehicle was impounded. So Ford F-350 was impounded. There was a K-9 sniff. From there was a warrant, and then items were found in the Ford F-150. And what I hear you say is, because they found those items, they may have gotten other warrants and led to other evidence that they want to use.
Yes, because of what they found in the illegal search, yes.
Okay. 88 Wu.
Judge, I disagree with the characterization. Again, the email talks about these residential search warrants. There were residential search warrants, but no charges were brought. There was one charge that maybe arguably relates to the residential search warrants that were brought. Most of the evidence that I've turned over, I received directly from victims. I conducted a huge part of the investigation in this case myself. And so this idea that all of this sprung out of a vehicle search, I'm not sure where that comes from. Also, the search warrant itself, an issue, sets out that an investigation was ongoing for about a month before the vehicle itself was even searched. So if you look at the affidavit to the search warrant itself, that defeats that argument. That's not accurate. Like I said, an overwhelming majority of the evidence that I've turned over was given directly by victims to me. It didn't come from law enforcement, didn't come from a search, didn't come from anything but directly to me from victims. And so that's why I'm struggling, because I don't know how to play defense against this motion if I don't know specifically what evidence we're talking about. It's easy to say all the evidence, but clearly all the evidence didn't come from the truck. It came from all sorts of different places. And so that's why I'm struggling. I'm not sure how the state can be on notice to defend against this motion when, certainly all the evidence didn't come from the truck. It just didn't. I mean, what's identified in the motion is a black book bag with documents. I don't know what documents we're talking about. A silver and black computer, I did not turn that over, it has nothing to do with my case. Gold iPhone, didn't turn that over, it has nothing to do with my case. A SanDisk 32 gigabyte USB drive, I didn't turn that over, it has nothing to do with my case. And keys to a vehicle, now the keys to the vehicle does have something to do with my case. It's a vehicle that he's charged with stealing, but I don't need the evidence that he had the keys to the vehicles. I'm willing to stipulate that I won't bring that evidence in. I don't need that evidence. And so that's where I'm struggling. I just don't know, unless we were to do a mini trial and go through every piece of evidence piece by piece, which the state can do, we're just not prepared to do that today because we haven't been put on notice of that. I'm not sure, again, how to play defense when it's not being specified or particularized what evidence we're talking about and how it came from this trial.
All right, so
Okay, so what Wooten is saying is basically my evidence comes from the victims, as she just said in the comments. I talked to them directly. I did a wide scope investigation, and my evidence comes from the victims directly. Now, what I surmise they will argue on the other side as the defense is you didn't even know who these victims were, allegedly, until you searched the car and maybe there were documents with their names on it. So that's still a connection. So somehow Hoover is trying to connect everything that you have originated from this search. Wooten is arguing, listen, the affidavit is very clear. They were investigating Mr. Williams for 30 days, even before his arrest. We know that the owner of the home, according to him, went to the police. Remember, he went to the police and he says something fishy is going on with my rental property, which made them, run license plates and all type of stuff. So Wooten is saying we got enough information that has nothing to do with these warrants that you're talking about. So that's basically what his argument is. So now we'll see what the judge says. And the judge does kind of break it down to say what I am hearing is, to try to make it clear, probably because it's a lot of people in the gallery, to make sure you guys are understanding this back and forth, what they're arguing, because I can't be there, to argue, to tell you guys what is going on in the courtroom. So the judge said, let me break it down for the people. But yeah. So the judge is trying to summarize what they are saying after their conversations to make sure that it's clear on the record what they are each arguing. So now the judge is going to talk.
all right, let me turn to the defense. So Attorney Hoover, what warrants are you looking to suppress?
So the warrants we're looking to suppress, Your Honor, are SW 030257, which was signed on July 8, 2022 for 990 Pine Grove, which is a residence. SW 030256, also signed the same day for 980 Pine Grove, which is another residence. EW 0371530, which is a warrant that deals with the deposit account fraud, which came from evidence in that vehicle, in the truck of the search.
And that's an arrest warrant?
Yes.
Okay.
Another warrant, EW 0371529. SW 030520, which relates to the silver and black GETAC computer. SW 031091 and SW 032563. All three of those warrants relate to the silver and black Getic Computer, SW030519 and SW031090, which relates to cell phones that were collected, SW030520, which relates to a ScanDisk 32 gigabyte USB drive, and SW031938, which relates to keys to vehicles that were found as well.
Okay.
And to make it clear, once again, I'm not trying to suppress the arrest warrant. I'm not trying to fight the arrest warrant. The state is hinging on, well, the arrest warrant was good, so ... To make it clear, I'm acknowledging the arrest warrant was a valid warrant. What I'm saying is I have to address it to get to the arrest, which got to the search, which got to everything else. And I want to do say, Your Honor, I think it's a little disingenuous for the state to say that I tell them a book bag in a vehicle with documents, but they don't know the documents, when it's literally evidence that they turned over to us that are acts in count 1 and actual charges in the indictment. So for the state to now say, well, we don't know what documents he's talking about, that's disingenuous. What we're talking about is he was arrested, the impoundment of the car was illegal, the search of the car was illegal, everything found in that illegal search led them on this investigation. Now the state told you that they got all this other stuff from other people. Your Honor, none of that happened until they illegally searched the vehicle, illegally got this evidence, and illegally went to those houses and the storage unit. It all started with the arrest. It all started with the illegal search. The issue here is the illegal search. The state just talks about there was an arrest and they got evidence everywhere else. Yes, there was an arrest. Yes, it was valid. The search is the problem. And because the search is illegal, everything they got from it afterwards, even the other stuff they collected, because it came from all of that information, is illegal. And it's disingenuous for the state to say they don't know what documents we're talking about, again, when they make up acts and charges in the indictment.
Mr. Wooten, anything else to add?
Judge, I think the listing of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 different search warrants for arrest warrant that are not mentioned in this motion to suppress proof the point I'm trying to make is, I mean, we've expanded from one search to 11 different things, arrest warrants, search warrants. I can't tell you based on the numbers here what even these search warrants are for. Now, what I can tell the court is that I did turn over the search warrants for each attack, the documents themselves. I did turn over the search warrants for the USB drive. I did turn over the search warrants for the cell phones because those were provided to me by the detectives, and I turned everything over again. But I didn't turn over what was discovered. I didn't turn over like the dump of the computer, the dump of the cell phone, etc., because I didn't receive those things. They're not part of my case. And so, like, I mean, for instance, and there's so much here to talk about, so I'm trying to hit the high notes, but for instance, the book bag, the documents in the book bag. Documents that would have come from the book bag, I assume would have been made part of the evidence from Roswell Police Department and then been turned over. I didn't turn over any documents that I received from the Roswell Police Department. What I can do is, to go bit by bit, is go to Roswell, get the book bag, open the book bag, see what documents are there. I mean, even Mr. Hoover could go with me. We could go together and see if those are part of what was turned over. But I don't, again, I represent to the court that I don't believe I've turned over anything that came from the search.
All right.
Okay, so someone said, I still don't understand how they're saying the first search was illegal. Well, none of us understand, honey, because we ain't got into the testimony yet. That's what we're trying to see. We're trying to see Investigator Fields, who was the head of all of this. She's going to get on the stand and she's going to get grilled and direct examined and cross-examined. So we're going to see why he's alleging that it was done improperly. So we're going to see how this flow went and if it was done according to how it's supposed to be done constitutionally. Now, what Wooten is arguing right now is he is basically saying With documents in a book bag that you're talking about, and I'm being disingenuous or whatnot, I didn't turn over any documents from a book bag, but we're free. You know, we can go do a field trip and we can go head over there to Roswell and we can see, because I'm assuming it's in evidence, and we can look and see what you're talking about and see if I turn that over, because that's not anything that I know that I turned over to you about some documents. So that's basically what he's saying. And ultimately the judge you're gonna see how the judge is going to decide how this hearing is going to go, because there is a hearing. That's why it was 2 hours. And we're going to see what the judge decides needs to happen before he can even get into any of these other warrants. Thank you, Miss J, for being a member for 9 months. I got some more super chats. Let me do this real quick. Sassy Experience, thank you for the super chat. She said, Black baby Jesus away in the manger, not the Christmas. 2.5 years later, I now realize body warrants equals arrest warrants. I Revive said, I knew they were going to try some domino effect argument. Thanks, Team Intellect. Thank you for the super chat. It's called Fruit of the Poisonous Tree. It's actually one of the first, if you do any type of criminal procedures when you're in federal criminal procedures, when you're in law school, it basically, you have a lot of motions to suppress. That's one of the first things you try to attack are the warrants. Because if you can attack the warrant, anything that happened from there's been cases that have been dismissed once the warrant has been suppressed. Because now everything that they've been able to get, whether it's witnesses, whether it's physical evidence, whether it's DNA, whether it's the actual GUN, all of that stuff will be suppressed if it was not executed properly. If they did not have the probable cause in order to even get the warrant in the first place. So yeah, it's something. Some people have said, oh, it's a technicality. It's really the law. Like, it's part of the procedures. There's certain procedures you're supposed to uphold. As the defense attorney, you make sure and you hold the state feet to the fire that they followed the correct protocol, that they do not violate your client's constitutional rights. Sassy said, Pam, after you gave us all the little tease last night, I promise I'll check back every 15 minutes until I fell asleep to see if you change your mind. Is it a chokehold? Yeah, it's some decent footage over here. We appreciate the videographer. Thank you so much for the super chat. I think that's it. I think we are caught up. All right, so let's get back. Thank you, Tanya. I appreciate the super chat. Said, thank you, Pam, for everything you do. Thank you so much for your support. Make sure you guys, it's 1,400 of you guys, hit the like button. Consider subscribing to the channel. This is what we do over here. If you like the content, please do so. Let's get back into it.
So let me try to understand in my head, and I think I know what we need to do at this point. I believe, Mr. Hoover, you're saying that suppression of the impound and search of the Ford 350 is going to necessarily lead to suppression of other evidence.
Yes, Your Honor.
If the impound of the truck, if that's found to be legal, then it would not suppress other evidence.
That's correct.
Okay, so let's deal with the impound of the truck. Let's deal with the impound of the truck. Then we can have the fight. If it's an illegal impound and illegal search, then you all can have the fight of what came out of that search and what evidence, as we say, is the fruit from that poisonous tree. Because what I hear Mr. Wooten saying is that's not a fruit from that tree. But let's first decide if the tree is poison before we go seeing what fruit it dropped.
Yes, Your Honor.
So if we could start there today. I've read the motion. Anything else, Mr. Wooten, you want to add before I turn to the state? I'm sorry, Mr. Hoover, on your motion before I turn to the state.
No, Your Honor, I'd just like to invoke the rule of sequestration.
Okay, all right. Any witnesses that may be called need to step out.
So invoking the rule of sequestration is anybody that is actually a witness. You can't sit here and listen to the testimony. So if it's 5 people that are witnesses and they're sitting in the gallery and you know you're going to be called to testify, you cannot hear what the previous person is going to testify to. Now, once you actually testify, you can sit in the gallery and watch it, but you cannot go listen to other people's testimony, because oftentimes people will try to fix their testimony into what the other person said. So he invoked sequestration and said, if you're going to testify, basically you can't be sitting in the courtroom listening to the testimony until after the fact. He's moving the camera, so he probably just breathing a little hard, y'all, because, or people around him. I heard it was people around that was also kind of asleep as well. But yeah, he's moving the camera, so I'm assuming that he's somewhat awake. Like, unless he getting up and then moving the camera a little bit. So he might be, I don't know what that is. But I'm gonna tell him, I'm like, they like you breathing kind of hard up in this camera. Sherry said it's definitely not the cameraman because the camera is moving. Yeah, he's moving all around. So I don't know. I don't know what that is, y'all. We gonna have to just, thug it out now. We got the good footage. Come on now. So now we're about to get into actual testimony. It's 1,500 of you guys. Make sure you hit the like button and subscribe. I'm gonna try to, with this, I'm just gonna listen to what she has to say, and maybe I'll just, chat with you guys in the comment section. I'm gonna let it go through. I just wanted you guys to have an intro so you know what's about to happen. So what the judge said was, well, before we get into it, we're going to try to see if the inventory search was legal. Because if the inventory was legal, then that means everything after that was legal. However, if the inventory was illegal, then of course everything after that has to be suppressed. So that's the one issue they're going to deal with, is whether the inventory was done appropriately. Let me go back because I think he said that.
50 is going to necessarily lead.
Let me go back a little.
Let me try to understand in my head, and I think I know what we need to do at this point. I believe, Mr. Hoover, you're saying that suppression of the impound and search of the Ford 350 is going to necessarily lead to suppression of other evidence.
Yes, Your Honor.
If the impound of the truck, if that's found to be legal, then it would not suppress other evidence.
That's correct.
Okay, so let's deal with the impound of the truck. Let's deal with the impound of the truck. Then we can have the fight. If it's an illegal impound and illegal search, then you all can have the fight of what came out of that search and what evidence, as we say, is the fruit from that poisonous tree. Because what I hear Mr. Wooten saying is that's not a fruit from that tree, but let's first decide if the tree is poison before we go seeing what fruit it dropped.
Yes, Your Honor.
So if we could start there today. I've read the motion. Anything else, Mr. Wooten, you want to add before I turn to the state? I'm sorry, Mr. Hoover, on your motion before I turn to the state.
No, Your Honor, I'd just like to invoke the rule of sequestration.
Okay, all right. Any witnesses that may be called need to step out. All right, yes, Attorney Wooten.
Judge, we're ready to proceed. We will start by calling Detective Natalie.
All right.
Judge, is it all right if I
Yes.
stay at the table?
Yes.
So Miss Fields, who we've heard a lot about, Detective Fields, she's about to take the stand. Before she takes the stand, I want to thank Jackie and Demetria for the cash apps. I appreciate you supporting the channel. Thank you so much.
State your first and last name and spell both the court.
My name is Natalie Fields, Natalie, last name Fields.
And Detective Fields, where are you employed?
I'm employed with the Roswell Police Department.
And what's your position there?
I'm a detective in our Special Investigations section.
And can you walk us through what other positions you've held at Roswell and how long you've been there?
Absolutely. I've been at Roswell almost 4 years. I started in uniform patrol, and I was promoted to detective in January of 2023.
So on July 7th of 2022, you were not a detective, you were in uniform patrol, is that right?
That is correct.
Okay. Can you explain what your duties were when you were on?
Y'all hear that? This is why, see, I said I wasn't going to stop it. But this is why they were saying that she made detective off of him, because she was just a field officer in 2022 when he was arrested. But in January 2023, she became a detective. So that's where they got it, where she made detective off of me, off of my case. Thank you so much. Dimples Wimple says save Hoover's chair. You know what? Thank you so much for the super chat. Okay, go ahead. I'm gonna try my best not to pause, but I guess I can't make any promises.
In uniform patrol?
As uniform patrol, we answer calls for service. If we have downtime, we can be proactive, whether it's traffic stops, looking for people's warrants, general day-to-day community service type, whatever the community needs.
And are you post-certified?
I am.
How long have you been post-certified?
3.5 years.
So you were post-certified on July 7th, 2022?
Yes, I was.
I want to shift gears to the defendant in this case, Ernest Williams. Can you tell me, are you aware of who Mr. Williams is?
I am.
And how did you first become aware of Ernest Williams?
I came aware of Mr. Williams. We had a gentleman come into the police department to follow up a report that their rent was not being paid for their property at 980 Pine Grove Road. That was my first time hearing Mr. Williams' name. After that, the landlord had stated that, he had started renting the property in the beginning of March, and after getting a rent check that came back as insufficient funds, when he deposited it, there was also an air AC unit that was supposed to be replaced. That check also came back as insufficient funds. And he had done, as a landlord, he had done a check of the property in June, and he had said that basically there was no furniture in the house. It was very strange. Like, there was a Bentley sitting outside, an ambulance, and 2 motorcycles, and he just wanted us to look into it. So I did. So I went by the house. There was, in fact, a Bentley sitting outside. This is $1 million+ home in a very affluent area of Roswell, and there was a Bentley parked. There were 2 motorcycles and the ambulance. I ran the tags. The Bentley did come back to Mr. Williams, and at that time I was able to see that he had warrants for his arrest. One out of Roswell, one out of South Fulton. I believe it was Henry County, and then 2 out of California. All of them for theft, fraud, and I then ran the motorcycles.
Actually, let me stop you.
Okay.
Let's kind of go through
Yep.
some of this
Sure.
piece by piece. So you said that Mr. Kroll, that's the victim who reached out to you, right?
That is correct.
Okay, and you said that was in early March of what year?
So he rented the apartment of March 2022, and Mr. Kroll came to the PD the beginning of June. I believe it was the 9th of June 2022 to make the report, because the money that he had received, the checks, when he deposited them, it had come back as not sufficient funds.
Okay, so is it fair to say that your investigation of Mr. Williams began on or about June 9th of 2022?
That is correct.
Okay. And just to be clear, is it your testimony that it began as an investigation into essentially some bad checks and potentially some fraud as it relates to renting a residence?
Correct.
Okay. And so from that point on, you kind of gave us some testimony about what you did. You went out, you observed the residents, you saw some vehicles. But can you kind of slow down and walk us through step by step with some timeline of each individual thing you did starting June 9th, 2022, and let's just go through the end of June, roughly.
Okay. So June 9th, is when the report happened, or Mr. Cole came in. I went and ran the tags the same day, and that's when we had already been told that about the non-sufficient funds, the check's not coming back. And so then I found out that same day that that Mr. Williams had warrants for his arrest. So then I started doing a little bit of investigation, and I ran the tags for both Harley Davidson that were on the property as well as the ambulance. The ambulance came back to Nesto's Elite Private Security. So I started investigating Nesto's Elite Private Security. We were able to find an LLC, but there really was not anything tied to the business. It was just basically an LLC and then a vehicle that was registered under this LLC. And then I ran the tag. One Harley came back to a female by the name of Regina Delaney, and then the other one came back to a female, Olivia Washington.
I want to take one step back first before
Yep.
we do the cars too. You said that you became aware that Mr. Williams had active arrest warrants, right?
That is correct.
What do you recall what those warrants were generally and what jurisdictions they were out of?
Yeah, so they were for theft and fraud, all 5 of them. We had one out of Roswell, which was theft by deception, I believe.
And that theft by deception, did you have anything to do with that case?
No, that had actually been a detective there, Detective Jackson, had pulled that warrant. I believe it was about a year or 2 years. It was during COVID, and he had taken money from a veteran and never followed through with the business.
Was that related to a credit repair service?
Yes, I believe so.
Okay.
I don't know a whole lot about that case in the sense, but yes, that was Detective Jackson's, and it was to do with repairing credit.
Okay, so there's the warrant out of Roswell. What were the other ones?
So the second warrant was out of South Fulton, and that was for theft also, but that was for a vehicle, which was a lady by the name of Melody Scratchin. That happened, I believe, that was filed in the beginning of June of 2022, that he had taken the vehicle of another. There was then a warrant, I believe it was Henry County, out of McDonough, that there was a trailer that he had taken, insufficient funds again. And then there were 2 warrants out of California, both again for theft. Further, once I had gotten the reports from California to see what those were for, one was for work that had been done on a Hummer, which he never ended up paying the bill. And then the other was for an RV that he gave $20,000, came back again as not sufficient funds. And then he was supposed to owe $85,000 on the RV, which he never paid, and the RV ended up in Florida where it was retrieved.
Okay, so all 5 of those warrants that were active either had something to do with theft, whether it's theft of money, theft of vehicles, or theft of vehicle trailers. Is that fair?
Absolutely, correct.
Okay. And I'm going to shift forward in time just a little bit. Let's go to July 7th, 2022. Were all of those warrants active on July 7th, 2022?
Yes, it was.
Okay. Now we're going to go back in time a little bit.
Okay.
Let's talk about the vehicles that you saw in the driveway at the Pine Grove residence. What vehicles did you see there?
There was a Bentley, regular car, the Bentley, 2 Harley Davidsons, and an ambulance.
Okay. And you said the Bentley was registered to Nesto's Elite Private Security, right?
So the Bentley was registered to Mr. Williams.
Okay.
It was under his name, and that is how I found out about the warrants, because once I ran the tag, it connected to Mr. Williams through GCIC, and then it pulled all of the warrants that he had.
Okay. It was the ambulance that was registered to Nesto's Elite Private Security.
Correct.
Okay. So let's talk about the motorcycles. Who were the motorcycles registered to?
The motorcycles, one motorcycle was registered to Regina Delaney, and the other one was registered to Olivia Washington.
The Regina Delaney motorcycle, based on your investigation, was there anything criminal going on related to that motorcycle?
Yes, so after I ran the motorcycle and I got Regina's name, I started doing a little investigation into those individuals, both Regina and Olivia, because it was property that was being held at a residence that was not in the leasee's name. So I found that Regina and Mr. Williams, they did have a case out of Sandy Springs, and she had filed a report with Sandy Springs that he had taken her motorcycle, a Harley Davidson, and a trailer. So there was that report with Sandy Springs. So looking from the road where I was, I could see very clearly Harley Davidson's a pretty iconic looking bike. And I was able to see that it was the same description as what was in the police report with Sandy Springs, which was a black Harley Davidson.
And then the other Harley Davidson that was registered to Olivia Washington. Did you find out there was anything criminal going on there?
So with Olivia Washington, I was able to eventually get in touch with Olivia, and she had said to me that her bike had been taken by Mr. Williams, and then she later did go and file a police report with Forsyth County for that bike.
But that was after July 7th?
Yes, that is correct.
And then did you ever see at that residence a Ford F-350 truck?
Yes.
How did you come to see that truck?
So I had found through the investigation that Mr. Williams was driving an F-350 that was white. Again, I was on uniform patrol, so call to service was my first job and priority. However, any kind of downtime that I had and the knowledge that I had that he had warrants, I wanted to go by the house and see if he would ever come so I could arrest him. During that time with the investigation, I was also trying to do surveillance on the house to see if, and I could ever see Mr. Williams coming and going and what was happening at the two homes that were next to each other. So there was a day that I went by the house and the Bentley that had been parked in the driveway was now removed and the F-350 was now parked. After the fact, the next morning I went back, the F-350 was now gone and the Bentley was now back. And so I knew that he had been driving the white F-350 and I had seen that now you've taken your vehicle that's registered to you and you left that vehicle behind and now it was swapped out again. So that's how I was, from the surveillance, I could see that the vehicles were changing.
Okay. And remind me, I believe you may have already said this, but did you determine who the white F-350 was registered to?
Yes, the white F-350 was registered to his wife, Shirley Strawberry, but he was seen in that vehicle and he was the one driving that vehicle.
Okay. To your knowledge, was Shirley Strawberry's name on the lease for either of the Pine Grove residences?
So for the Pine Grove residence, yes. So it was listed for Earnest Williams, Shirley Strawberry, her daughter Sheridan Strawberry, and then two minors was what was listed on the lease as the occupants of that house.
Okay. And did you have any information? I know you testified that the landlord told you that there was no furniture at the Pine Grove residence. Did you have any information that Mr. Williams was living somewhere else?
I did not have information on Mr. Williams living somewhere else at that time. I did find out that they had a previous residence, 2155 Bank Creek, which was Alpharetta, and they had been living there, but they had signed a lease in March of 2022, so that was what was given as what his current residence was.
So let's fast forward again to July 7th, 2023.
Okay.
Did you encounter Mr. Williams at some point on that day?
Yes, I did.
How did you encounter him, and how did you end up in the position where you encountered him?
So I was actually, so the way Roswell's broken out, we are put into different zones on our patrol shift. So I was actually assigned to Zone B that day. I was in Broadway Zone, which is where the house that he was leasing sits in. So in between calls, I was doing some surveillance on the house that day. I'd been there earlier in the day. Nothing was really happening. and I got called out. So I went off to a call, and then it was early afternoon. I was free and available, and so I headed straight back out to 90 Pine Grove. As I was driving westbound on Pine Grove Road, and I got to High Tower, which is perpendicular to Pine Grove Road, and there was a white F-350, and I immediately recognized the driver to be Mr. Williams. He was traveling eastbound, I was traveling westbound. So it's a 2-lane road, and so I needed to get in the same direction. I now had seen him, and I was going to do a traffic stop on him on the vehicle. So I turned my car around. I actually went ahead and called to another officer for backup. And so I now was traveling eastbound on Pine Grove, and I probably had about 4 or 5 cars between myself and Mr. Williams. And so I had asked the other officer who was actually coming from the station, I said, this is our location, this is where we're going. If you get behind him, go ahead, make the traffic stop. I've got some cars between me and Mr. Williams. Mr. Williams actually then pulled off of the road into 1007 Alpharetta Street, which is where there's a Domino's and some other little businesses in there. And he had pulled his truck in to respond to the parking spots. And by the time Officer Yevtushenko and myself were able to pull into the parking lot, we just pulled our vehicles behind his vehicle, and Mr. Williams had gotten out of his car, and he was taking a picture of a sign for the property where it said for lease. I got out of my patrol car, and I already knew who he was, but I went ahead and said, Mr. Ernest Williams, and he said yes. I said, sir, I have I have a warrant for your arrest. And I'm taking you into custody. At that point, I took Mr. Williams into custody with Officer Yevtushenko there. Once he was in custody, I then transported him to the Roswell Police Department, which is not, I don't even think it's half a mile from where he stopped and he was taken into custody, to then meet with Detective Gooden to interview Mr. Williams.
Okay, Detective Gooden, what's his full name?
Detective Dwayne Gooden.
And how was he involved in this case?
So Detective Dwayne Gooden, he was a detective in special investigations at the time. I had done kind of like a training with him on another case earlier in the year, and so when this case came into me, or came into the police department, and I started seeing everything that was going on, I immediately went to Detective Gooden and I said, you know, I think we have something here. Will you work this with me? Because I was on patrol and he was the detective at the time. So he looked at everything and he said, I absolutely think we have something here. Looks like this could be a good case. Let's start working it. We'll work it together.
And when did that conversation take place?
That took place probably like June 10th, maybe the day after, or maybe a couple days. Very early on. So Detective Gooden and I started working the case together. He did a lot of the interviews with the landlords, and we were both kind of tag teaming the investigation. And we just kind of moved forward from there. And so that's how he came to be. And at the time, he was considered the lead as he was the detective on the case.
I'm going to jump around one more time to give you some details we need to fill in. You mentioned that Detective Gooden and you had done some interviews with landlords related to the Pine Grove residences. Was there ever an instance in the course of that investigation, prior to July 7th of 2022, where you began to suspect that Mr. Williams and any potential co-conspirators may be committing identity fraud?
Absolutely.
And can you explain that?
Yes, so we had started looking into, so the documents that Mr. Pearl had given to us at that point, so there was even the document that was submitted for the lease itself, it said Ernesto Williams, it said Shirley Sheridan Strawberry. Sheridan is not Shirley Strawberry's middle name. Sheridan's name was spelt wrong. And then the signature line on that lease was signed as Sheridan Strawberry. Well, Sheridan Strawberry is not the wife of Mr. Williams, and then Mr. Williams had signed it. There was another form that, under Black Heritage Radio Trust that was submitted, and on that form,
Y'all see how Nesto immediately started writing when they said that Mr. Williams signed it because he wanted to write down to his lawyer, I didn't sign anything. What are they talking about? I don't even know anything about this lease.
there were multiple names. Sheridan's name is on it again, is that this was the trust. So I think the way the lease read was at the top it said Black Heritage Radio Trust is leasing this and these are the occupants. And then on the Black Heritage Trust radio paperwork was Mr. Williams' name, there was Sheridan Strawberry's name, and then it had, I believe it was Candy Relaford. I don't have the document in front of me at this present moment. I think it was like a Jeff Relaford and then Charleston White. And so those were the names that were on that was also submitted.
Did she say Charleston White? Because wasn't he wait, let me back this up a little bit. Okay.
Gooden and you had done some interviews with landlords related to the Pine Grove residences. Was there ever an instance in the course of that investigation, prior to July 7th of 2022, where you began to suspect that Mr. Williams and any potential co-conspirators may be committing identity fraud?
Absolutely.
And can you explain that?
Yes, so we had started looking into, so the documents that Mr. Pearl had given to us at that point, so there was even the document that was submitted for the lease itself, it said Ernesto Williams, it said Shirley Sheridan Strawberry. Sheridan is not Shirley Strawberry's middle name. Sheridan's name was spelt wrong. And then the signature line on that lease was signed as Sheridan Strawberry. Well, Sheridan Strawberry is not the wife of Mr. Williams, and then Mr. Williams had signed it. There was another form that, under Black Heritage Radio Trust that was submitted, and on that form there were multiple names. Sheridan's name is on it again, is that this was the trust. So I think the way the lease read was at the top it said Black Heritage Radio Trust is leasing this and these are the occupants. And then on the Black Heritage Trust radio paperwork was Mr. Williams' name, there was Sheridan Strawberry's name, and then it had, I believe it was Candy Relaford. I don't have the document in front of me at this present moment. I think it was like a Jeff Relaford and then Charleston White. And so those were the names that were on that.
So y'all know Charleston White has done interviews on Tasha K and was saying that he allegedly got scammed by Erica. Because remember, y'all, I asked Erica about the Charleston White and how the name was being connected, and she was kind of acting like, what you talking about type thing. So apparently, according to her, Charleston's White name was on this list under the Black Heritage Trust, and they was listing different people, and they had Mr. Williams, Sheridan. It may have had Relaford, which I think is Erica's husband, I think. Maybe not. Relaford, whoever that is, because that was on something else. And then Charleston White. Very interesting. Go on, Ms. Fields. Go ahead. Go ahead, Detective.
That was also submitted.
Okay. So Black Heritage Radio Trust, did you investigate what that entity is?
So we started investigating it, and we could find nothing to show that it was legit. It was coming in as that it was like a nonprofit. I remember running the business number, the EIN for it, and it came back to like an accounting firm in Tennessee. And so all of that was not correct at the time. Knowing the documents as well, we also then had a cease and desist letter that was turned over to us, which,
now, before we get into that,
yeah.
So you said that there was an EIN on some paperwork in the lease documents that was supposed to be
Black Heritage Radio Trust.
And it was not.
Correct.
So fair to say fraud.
Correct.
Okay. And then you mentioned the name Candy Relaford.
Yes.
Can you tell me about that person? Did you determine whether or not that's a real person or not?
So Candy Relaford was not her real name. The real individual is Erica King. Erica King She is the one who dealt with Mr. Kroll to begin with. She had stated that she was renting the houses on behalf of her clients who were famous, and that she needed to have that information come through her. She was renting 990, which was next door to 980.
And when you say that Erica King dealt with Mr. Kroll, was she dealing with him as Erica King or as Candy?
As
Relaford?
Candy Relaford, correct. She had many aliases. Candy Relaford was one of them. And that's who she was dealing with Mr. Kroll as getting the lease, or helping them get the lease.
And all this was prior to July 7th?
Yes, correct.
Okay.
And then she was also, so the other part was Mr. Kroll had said he had paid a lady by the name of Tammy Strong, who was a real estate agent, and that he paid her $1,000 to help get someone to rent the home. Well, as we continued the investigation, we realized that the phone number was the same, and during this time, and that Tammy Strong was also another alias that Erica King had. So she was not only playing, I'm getting the lease for this person, but she was also playing the real estate agent and getting the money to bring the client in.
Okay, and when you say the telephone numbers were the same, are you saying that there's documentation where a number for Candy Relaford is also a number for Tammy Strong?
There was yes, and that's how we started figuring out her aliases, is that the phone numbers were connecting.
Okay, and then you started to mention a cease and desist letter at one point that was sent to Mark Kroll.
Yes.
What, if you looked at that letter, who did it purport to have been sent by?
It was sent by Goldberg Sutton, LLC, which was a law firm, and at the time, I'm trying to remember what the attorney's name that she put on it, Mormon, the last name was Mormon.
Nicole Mormon?
Yes, I think, yes. And basically, we contacted the attorney, and she said, I never sent that letter, and she wasn't even associated with Goldberg Sutton. Now, when you looked up Goldberg Sutton online, the website had pulled images from other websites, and there were some parts of the website that weren't even finished. And so we were like, okay, something is afoot here. And so then later on, we found out that she was then posing as another attorney as April Holloway, where she actually sat in Fulton County Court as April Holloway, and April Holloway as well said that she has never represented Mr. Williams and that she's never had any part of any business with him.
And to be clear, what you testified to about April Holloway, that happened after July 7th. Your knowledge of that?
Right, we started finding out about the April Holloway. I did find the first mention of April Holloway came off of the Sandy Springs report, because after Regina Delaney had filed with Sandy Springs that Mr. Williams had taken the bike.
And let me just stop you
Yes.
to be clear. When you say the Sandy Springs report, you're talking about, you previously testified that one of the Harley Davidsons at the Pine Grove residence had
Correct.
been reported stolen in Sandy Springs, right?
Correct,
Okay,
yes.
go ahead.
And so there was a letter sent, a certified letter sent to their residence at 2155 Bank Creek. And the letter that was sent was actually done by Goldberg Sutton, but now the attorney's name is April Holloway. So that's the first time we actually heard of April Holloway. And now we've got two attorneys, and that's what led to further investigation into April Holloway and the use of that name.
And so to be clear, everything you just talked about, with the exception of some of the April Holloway stuff, was all ongoing active investigation on July 7th, 2022.
Correct.
Okay. So let's go back to July 7th, 2022.
Okay.
You testified that you saw Mr. Williams driving a truck, you got behind him and you pulled into a parking lot, you arrested him and took him to the station, right?
That's correct.
Okay. Let's set the timeline a little bit. From the time you made contact with him in that parking lot, how long was it before you arrested him?
Maybe 45 seconds. I mean, I literally pulled my car and I knew he had a warrant. And so I literally pulled my car in, I got out of the car, I walked from my car to the sign where he was standing, and I said, Mr. Ernest Williams, and he turned around and looked at me, and he said, yes, and I said, you're under arrest, I have a warrant for your arrest. I took him into custody, and then, you know, very quickly, I mean, obviously per policy, we have to do a pat-down search before anyone is put into a vehicle. So we did search him, and then we placed him into the vehicle, and then I transported him to the police department.
Okay, is it fair to say that from the time you put him into custody to the time you got to the police department in 10 minutes or so?
Yeah, probably. It may be because whenever, so kind of like when we arrest or we're taking someone into custody like that on a warrant, we always call through dispatch to make sure that the warrant is active and that we can actually bring them in and that the jail will take them. So that's also part of that process. So sometimes, you know, that may add a couple minutes because dispatch does have to call and confirm the warrant. And so, I mean, but that doesn't take that long.
And did you do that in this case?
Absolutely, every single time.
And the warrants were good, right?
Yes, the warrants were good.
So you get back to, let's go back to when you return to the police station.
Mm-hmm.
Is Mr. Williams with you at that time?
Yes.
Okay. And then when you got back to the police station with Mr. Williams, who did you speak to?
Immediately spoke to Detective Gunn.
Okay. And what was that conversation?
I immediately said to Detective Gunn, I said, I have Mr. Williams here, we need to do the interview. And then we started talking about his vehicle.
Okay. And when you arrested Mr. Williams, what did you, initially when you arrested him, what did you do with that truck?
I immediately locked it to secure it. And I actually tried calling Detective Gooden on my way so that I could speak with him on the vehicle. And when I got to the station is when I didn't get to speak to him. So immediately as I got to the station, I took Mr. Williams and put him straight into an interview room, which is where Detective Gooden then came downstairs because I reached out to him again and he met me at the interview room.
Okay. But the truck remained in the parking lot?
Yes.
At that point, right?
Yeah, on federal property.
Okay. And so you get back, you talk to Gooden. Did you have a conversation with Gooden about the truck at that time?
Yes, I just said to him that I brought Mr. Williams over and that the truck I had to lock and is at this location.
Okay. And did you have any conversation about what needed to happen with the truck from that point?
Yes, immediately Detective Gunn said we need to tow the vehicle for investigative purposes. So we will bring the vehicle back, we'll impound it on an investigative hold, bring it to Roswell PD and place it into the back lot, and then we will obtain a search warrant to go into the vehicle.
Okay. At the time that you arrested Mr. Williams, you said there was keys to the vehicle in his possession?
Yes,
How many sets of keys?
there was one set of keys.
Okay. And based on your training and experience, when you purchase a vehicle, how many sets of keys do you normally get?
2.
Okay. Did you have any knowledge of where another set of keys for that vehicle might be?
No, absolutely not.
So you have a conversation, Gooden says we gotta get that truck impounded, hold it for investigative purposes, get a search warrant.
Correct.
Is that what happened?
Yes.
Okay, yeah. So this is where we're getting into after the arrest and then the impounding of the vehicle. All right. So this is the big sticking issue. Everything that they've talked about before has just been, she's establishing, we were watching him before. We kind of went over that. There was some issues with some bounce checks, and then it led to running plates, and then they found about a stolen motorcycle. Then he had other warrants and all of that. So they have been watching him for 30 days before they even arrested him based on one of the Roswell warrants that were out there for something totally unrelated. So now we're actually getting to the impound portion of it because he's arrested. So I'm gonna back it just a little bit, because this is the part where we'll see how she's trying to establish that everything was done on the up and up and it was legal. So I'm gonna go back just a little bit, 1 minute, and then we'll start from there.
And put him straight into an interview.
Oh, and thank you guys for letting me. I set a goal for 10 super chats about 10 minutes ago, and you guys have helped me with my goal. So thank you guys so much. I appreciate all of the love and support.
Room, which is where Detective Gooden then came downstairs because I reached out to him again and he met me at the interview room.
Okay. But the truck remained in the parking lot?
Yes. Yeah, on federal property.
Okay.
Wait a minute, let me go back a little bit more.
So we did search him, and then and that's what led to further investigation into April Holloway, and the use of that name.
And so to be clear, everything you just talked about, with the exception of some of the April Holloway stuff, was all ongoing active investigation on July 7, 2022.
Correct.
Okay. So let's go back to July 7, 2022.
Okay.
You testified that you saw Mr. Williams driving a truck, you got behind him and you pulled into a parking lot, you arrested him and took him to the station, right?
That's correct.
Okay. Let's set the timeline a little bit. From the time you made contact with him in that parking lot, how long was it before you arrested him?
Maybe 45 seconds. I mean, I literally pulled my car and I knew he had a warrant. And so I literally pulled my car in, I got out of the car, I walked from my car to the sign where he was standing, and I said, Mr. Ernest Williams, and he turned around and looked at me, and he said, yes, and I said, you're under arrest. I have a warrant for your arrest. I took him into custody, and then, very quickly, obviously per policy, we have to do a pat-down search before anyone is put into a vehicle. So we did search him, and then we placed him into the vehicle, and then I transported him to the police department.
Okay. Is it fair to say that from the time you put him into custody to the time you got to the police department in 10 minutes or so?
Yeah, probably. It may be, because whenever, so kind of like when we arrest or we're taking someone into custody like that on a warrant, we always call through dispatch to make sure that the warrant is active and that we can actually bring them in and that the jail will take them. So that's also part of that process. So sometimes, that may add a couple minutes because dispatch does have to call and confirm the warrant. And so, but that doesn't take that long.
And did you do that in this case?
Absolutely, every single time.
And the warrants were good, right?
Yes, the warrants were good.
So you get back to, let's go back to when you return to the police station. Is Mr. Williams with you at that time?
Yes.
Okay. And then when you got back to the police station with Mr. Williams, who did you speak to?
Immediately spoke to Detective Gillen.
Okay. And what was that conversation?
I immediately said to Detective Gillen, I said, I have Mr. Williams here, we need to do the interview. And then we started talking about his vehicle.
Okay. And when you arrested Mr. Williams, what did you, initially when you arrested him, what did you do with that truck?
I immediately locked it to secure it. And I actually tried calling Detective Gooden on my way so that I could speak with him on the vehicle. And when I got to the station is when I didn't get to speak to him. So immediately as I got to the station, I took Mr. Williams and put him straight into an interview room, which is where Detective Gooden then came downstairs because I reached out to him again and he met me at the interview room.
Okay. But the truck remained in the parking lot?
Yes. Yeah, on federal property.
Okay. And so you get back, you talk to Gooden. Did you have a conversation with Gooden about the truck at that time?
Yes, I just said to him that I brought Mr. Williams over and that the truck I had to lock and is at this location.
Okay. And did you have any conversation about what needed to happen with the truck from that point?
Yes, immediately Detective Ginn said we need to tow the vehicle for investigative purposes. So we will bring the vehicle back, we'll impound it on an investigative hold, bring it to Roswell PD and place it into the back lot, and then we will obtain a search warrant to go into the vehicle.
Okay. At the time that you arrested Mr. Williams, you said there was keys to the vehicle in his possession?
Yes,
How many sets of keys?
there was one set of keys.
And based on your training and experience, when you purchase a vehicle, how many sets of keys do you normally get?
2.
Okay. Did you have any knowledge of where another set of keys for that vehicle might be?
No, absolutely not.
So you have a conversation, Gooden says we got to get that truck impounded, hold it for investigative purposes, to get a search warrant.
Correct.
Is that what happened?
Yes.
Okay. Can you kind of walk us through what that process looked like? If you recall, if you were part of that process.
So I was at the police station. So at that point, because I had Mr. Williams in my custody, I was staying with him. And so immediately, as I got back, Detective Ginn and I had this conversation, and I say, Detective Ginn goes, let's go ahead and tow the vehicle back here. Officer Yavtushenko immediately went back to the vehicle. He, at that point, per our policy, did a very basic inventory of the vehicle and waited on the tow truck. The tow truck then took the vehicle back to the Roswell Police Department. Officer Yavtushenko followed it. It was then placed into our back lot where it was on secure property at that time, which is where it stayed until we obtained the search warrant the following day for it.
And so at the time, prior to the vehicle actually being impounded and taken to the police department, at the time that you placed Mr. Williams under arrest, and you're investigating all these various crimes, you've seen him driving the vehicle, you've seen the vehicle at the residence on Pine Grove, did you believe at the time you placed him under arrest that you had probable cause to believe that there was evidence of some crimes in that vehicle?
Absolutely.
And can you explain to me, or just articulate what that belief was based on?
The belief is based on the fact that he had multiple warrants for his arrest when it came to theft. We had done a lot of investigation, so a lot of white collar and fraud is documents. And so he was coming from the house. He was obviously going back and forth. He was living at that, supposed to be living at that residence per the lease, which is where, you know, people would have their belongings. If he's transporting belongings, they would be in that vehicle. So yes, we absolutely believe that we had probable cause for the items in that vehicle.
Okay. And fair to say that based on your investigation to that point, you had knowledge that Mr. Williams had been in possession of stolen vehicles as well?
Absolutely.
Okay. So let's use that as kind of one of our lines of demarcation. The moment that you place him under arrest. So we kind of talked about everything prior to that, and we're going to go in front of that.
Okay.
Did you and Detective Gooden have any opportunity to speak to Mr. Williams once he was at the police station?
Yes, Detective Gooden did. I was watching on the screen, and then, you know, every once in a while, Detective Gooden and I would have a very brief chat. And Mr. Williams he didn't really want to speak. It was more, which was fine. And it was just basic like housekeeping stuff. And at that time, I know he had wanted to get a couple numbers out of the phone before I took him to Fulton County Jail, which is something, to be honest with, most people will absolutely do, so they have a phone number. Detective Gooden asked him, you know, do you know the numbers so you can write them? And he said, no, they're in my phone. And so with consent, Detective Gooden asked him for the passcode, opened the phone in front of him to get the two phone numbers that he wanted. The first phone number was his wife, Shirley Strawberry, and the second phone number that he wanted was, the way he originally put it, was he wanted his attorney's phone number, Erica King, and then later stated, oh wait, but no, she's actually just a paralegal.
So he said that he...
Wait, what? So the first number he wanted was Shirley Strawberry, and the second number was, he said, was his attorney, which was Erica King. Lord.
Knew at that point she's not actually...
Correct. And the number that he asked for was the same number that we had seen in the investigation previously to his arrest that was connected to Erica King.
Is that the same number that was connected to Candy Rutherford and Tammy Strong?
That we had seen, yes.
Okay. And then did Mr. Williams ever say anything at all about any documents in the trial?
Yes, he had made reference to Detective Gooden that basically he was like, you know, I'm really worried about the documents in my vehicle to do with like Nesto's elite buckhead. So he had made reference that he was very anxious over those documents. We had also seen that there was a suitcase and multiple bags in the car, which were in plain view. So there were multiple items within the vehicle that were, you know, a suitcase was one of them that would make one believe that someone's going somewhere or traveling.
And to this point, and I'm talking before you ever got a search warrant or anything, did you ever open any of those bags, and we're gonna talk about the medicine in a second, but other than the medicine, did you ever search or open any of those bags?
No, we did not.
Okay. And then let's just talk about a bag with, was there a bag with medicine in it?
There was a little bag that Mr. Williams had said, I don't remember what the medicine was for, to be honest, but he mentioned that there was medicine that he took daily and that he needed it. And it was in, my memory serves me correctly, it was like, I guess almost like a little kind of, very small little black kind of backpack. And he said the medicine was in that bag and that it was on the front seat. So we asked for consent to just open the vehicle, grab that to get the bag of his medicine, and that's exactly what I did. I walked to the vehicle, I opened the front door, took it off the front seat, and I just picked the entire bag up and took it to him so he could get the medicine out of his bag.
Okay. And to be clear, fair to say that he requested that you go get the medicine out of the truck?
Yes.
Can I have first witness?
Yes.
Take the fields, I'm going to hand you what's the pre-market identification purposes of State's Exhibit 1. Can you take a look at that document and don't tell me what the contents of the document is, but do you recognize that document, and if so, how do you recognize it?
Yes, this is the search warrant for the F-350.
And the document that you have there in front of you, did you personally swear out a search warrant for the F-350?
I did.
The document that you have in front of you there, is it a copy of that search warrant?
Yes, it is.
And does it appear to be a fair and accurate copy of the search warrant, the original search warrant?
Yes, it is.
Does it appear that there's been any alterations to it?
Not that I can see without reading it. So, yes.
Why don't you actually take a minute, look through it, and let me know if it appears that anything's been altered.
Everything looks, it does not appear to be altered.
All right, this time, a move State's Exhibit 1 into evidence.
Any objection, stage one?
No objection to stage 1, Your Honor.
Stage one is admitted without objection.
Thank you, Judge. And Detective Fields, so turning to Exhibit 1, you testified that this is the search warrant for the F-350, right?
Yes, that's correct.
And is it fair to say there's actually a couple documents here? There's the warrant itself, there's the affidavit and application for the warrant, and then there's a return that you filled out after searching the vehicle.
Yes.
And looking at the search warrant itself, you see on the second page that the search warrant was signed by a judge.
Yes.
What judge was that? And you see when they signed it?
It was Judge Debbie Ann Rickman, and it was signed on July 8th, 2022 at 2:44 p.m.
And July 8th, 2022 at 2:44 p.m. Approximately how long was that after when you placed Mr. Williams in custody?
So it was probably 24 hours. It was approximately 24 hours. I don't remember the exact time I took him into custody, but I know it was in the afternoon. It was approximately around maybe 2 or 3 that I took him into custody.
Okay. And so I want to move into the affidavit itself. Just a couple very brief questions about the affidavit. Looking at the affidavit, you've got some numbered paragraphs. You see that?
Yes.
And can you go all the way to the end of that list of numbered paragraphs and tell me what the last number is?
21?
Okay. And do you see in paragraph 18, paragraph 18 mentions when you encountered Mr. Williams on July the 7th, arrested him, and everything that happened from there?
Yes, I see 18.
Okay. And as you wrote this affidavit, is it fair to say that you wrote it in chronological order?
Yes.
And so is it also fair to say that paragraphs 1 through 17, all the information contained in 1 through 17, you obtained prior to you encountered Mr. Williams on the 7th and arrested him?
That is correct.
And then, when was the actual search of the vehicle conducted?
The search of the vehicle was conducted on July 8th. So
Same day?
same day, we basically got the search warrant, it was signed, and we immediately just got evidence bags or whatever we needed to go and conduct a search warrant and immediately went.
And what did you document what you found as a result of that search?
Yes.
And what did you find as a result?
So on the car receipt, we have a black book bag with documents, silver and black G-Tech computer, a gold iPhone with black and white cover, a scan disk, 32 gigabyte USB drive, and then keys to a 2002 Prevost Liberty, which was keys for an RV.
And then once all that evidence was marked in the bag, where was it stored?
So the evidence was placed or it was put into evidence. The book bag was secured in the Special Investigations office where it was for photocopying, and then it was placed into evidence. And then the computer and the iPhone, all of those were put into evidence until warrants were taken for them to come to Fulton County for their download report, the forensics of those items.
Okay. And all of these items listed, to your knowledge, do they still remain in the custody of the Roswell Police Department?
Yes, they do.
Judge, just no further questions at this time.
Cross-examination?
Yes, Your Honor.
Okay, y'all. So now we're going to get into Hoover's Cross. She's basically, for those of you that were wondering, she has attempted to establish that she said she arrested Mr. Williams. She took him down to the station. She left the car on the private property. The detective that was over the case that issued the warrant in the first place, or was a part of the warrant in the first place, said, hey, we need to get this vehicle and tow it for investigatory purposes. She said she believes she had probable cause that it was stuff in the vehicle. Within 24 hours, while it was impounded, while it was on an investigatory hold, she went and got a search warrant to actually search the vehicle. So I think what he's trying to argue, well, I guess we'll see what he's trying to argue, is that it should have never been an investigatory hold, perhaps, in the first place on the vehicle. So he's about to cross. So let's see how Hoover does on the cross-examination.
Good afternoon, Officer Fields.
Good afternoon.
My name is Sean Hoover, and I represent Earnest. I have some questions for you as well. And you said you've been with the police department for 4 years now?
That is correct.
And I guess when you started, you went to the police academy, right? They just didn't put you out on the streets.
That's correct.
And in the police academy, they taught you how to do various phases of your duty as an officer, correct?
Yes, that's correct.
One of those phases dealt with investigations, correct?
That's correct.
In regarding investigations, you were taught how to write your report based off of your investigation, correct?
That is correct.
And you were taught that you had an obligation for your report to be truthful, right?
Yes,
You were taught you had an obligation for your report to be accurate,
correct.
and you were taught you had a right, or you had an obligation for your report to be complete.
Correct.
And that's important because not only are you relying on your report, but everybody else is, right?
That is correct.
And you did write a report in this case, correct?
That is correct.
And it was a complete, truthful, and accurate report,
That is correct.
meaning everything that was important in your investigation was memorialized in this report. Now, you were a detective now, but you were on patrol back during this investigation in 2026. Okay. You said your zone was Zone B in Roswell?
On that day, it changes daily.
So on that day, it was Zone B.
That is correct.
Now, based off of your complete and accurate report, on July 7, 2022, that's when you parked in front of 990 Pop Road, right?
That is correct.
To conduct surveillance.
That was one of the days, yes.
Okay. And at some point, you put in your report that you left the residence,
That is correct.
and then you came back again.
That's correct.
Okay. And as we were driving back, that's when you saw the white F-350
On that day, yes.
on that day. Okay. And you noted in your report that that vehicle was registered to Shirley Strawberry. And I'm sorry, because of the court.
No, that's fine.
And you also noted in your report that Earnest was the one driving.
That is correct.
Now, you never memorialized anything in your report that Shirley Strawberry had any active warrants or anything like that, right?
No, there was no active warrants for Shirley Strawberry.
And you never memorialized anything in your report stating that that F-350 was involved in some type of crime, right?
No.
You never memorialized anything in your report stating that you witnessed Ernest Williams commit some type of traffic violation in the F-350 that day.
I did not know.
And in your report, the only warrant, when speaking on this day about the arrest, the only warrant that you put in your report was EW 0328723, which was the Roswell theft by deception, correct?
I do not remember if that's the only thing.
If you need to look, would it help refresh your recollection?
If you have that report that day, sure.
May I approach? Yes. All right. I am handing you the report that the state gave us, starting on page 21 where it says Williams arrest.
Okay.
Go ahead and take a look at it. Let me know when you're ready to talk.
However, I had listed all of his reports earlier on in that report, his arrest, or warrants for his arrest earlier on in the report.
Yes, ma'am. So my specific question was, in your complete, truthful, and accurate report, when you memorialized seeing Mr. Williams in the F-350 that day, the only warrant you memorialized was the Roswell theft by deception.
On July 7th, I put that in there, but it's memorialized earlier for the warrants that he has. And Roswell, I don't remember what was in my mind that day. I would say you probably went to the Roswell one because that's where I work. But there were other ones that he was being arrested for.
And it's interesting you said you don't remember what was in your mind that day. That's why you were taught that your report had to be complete, accurate, and truthful, right?
Absolutely.
All right, so you wrote down what was in your mind that day.
Okay, so yeah, he had a warrant for Roswell.
Thank you.
Memorialized before that he had multiple warrants.
Thank you. All right. And by the time you got to Mr. Williams, he was already out of the vehicle, correct?
That's correct.
He was walking around the parking lot.
That's correct.
And I believe you said he was taking pictures of for a lease sign?
Yes.
Okay. So the vehicle was not moving when you got there, right?
No, it was not moving.
The vehicle was parked, correct?
That's correct.
You never memorialized in your complete and accurate report that that vehicle was obstructing the flow of traffic on the street, did you?
No, because it wasn't.
You never memorialized in your complete and accurate report that that vehicle was obstructing the flow of traffic into that parking lot, did you?
No, because it wasn't. It was in a parking space.
You never memorialized in your complete and accurate report that that vehicle was causing any type of danger to anyone on the street or in the parking lot, did you?
No.
And as you said, it was legally parked in the parking space, correct?
Yeah.
And you never memorialized anything in your report stating that the owner of that lot said, hey, we want you to move that vehicle.
No, because we didn't speak to him.
And you never memorialized anything in your complete and accurate report saying the owner of the building wanted you to move that vehicle.
No.
You never memorialized anything in your complete and accurate report that you yourself smelled any type of drug on Mr. Williams that day, did you?
No.
And you never memorialized anything in your report saying another officer told you they smelled drugs on Mr. Williams, did you?
No.
You never memorialized anything in your report stating that you believe Mr. Williams was under the influence of any type of drug based off the way he was acting or speaking.
No.
You never memorialized anything in your report that any other officer believed that as well, correct?
No.
You never memorialized anything in your complete and accurate report that you believe there were drugs in that truck the day you arrested Mr. Williams, did you?
No, not at that time.
And you never memorialized anything in your report indicating that another officer believed there were drugs in that vehicle, did you?
No. That's fine.
You never memorialized anything in your report indicating you believe there were drug-related objects in that vehicle that made you arrested Mr. Williams, correct?
Correct.
You never memorialized anything in your report that any other officer believed there were drug-related objects in that vehicle the day Mr. Williams was arrested, correct?
Correct.
You never memorialized anything in your report that stated that Mr. Williams looked like he was getting rid of drugs or drug-related objects when he was arrested, correct? And I believe he was put in the back of your vehicle when he was arrested. You never memorialized anything in your report saying you smelled drugs on the inside of your vehicle once he was in. You also never memorialized in your report that you saw any drugs or drug-related objects in the back of your car after Mr. Williams was in there, correct? And Mr. Williams was arrested without incident, correct? He didn't try to fight anybody. He didn't obstruct anybody. He didn't resist anybody. He wasn't moving in an aggressive manner. He basically turned around, put his arms behind his back, and got handcuffed peacefully, correct? I'm going to butcher his name. What was the name of the other officer that was there as well?
Officer Ivan Yevtushenko.
Yevtushenko. Okay.
So I'm gonna stop just for 1 minute because a couple of people have made the comments of, I thought he was arrested because he had warrants. He absolutely was arrested because he had warrants, but you have to keep in mind the reason why this hearing is happening is because he's not challenging the arrest warrant. The warrants were out there. They were what they were. What he is challenging is anything that has to do with this car and receiving a search warrant to be in that car. So to even get the information out of that car, which actually led to other search warrants. That's what he's trying to establish. So I'm going to assume based on this that somehow, because I did hear something about some dogs sniffing. So I don't know what the affidavit for him to receive the warrant, what facts they gave. But I'm going to assume that perhaps those facts were not what Ms. Fields said, which was, well, we knew all of this stuff prior before. And so based on what we knew, as far as, the white collar crimes being in the car, they must have had, we got to look to see the reason why they got the search warrant in the first place. So you guys are absolutely correct. There was already a warrant. So probable cause related to arrest is not an issue. It's not about the arrest. It's about the search. So just keep it in mind. It's about the search. Because if you look at it, if this evidence gets suppressed, then a lot of this evidence that is suppressed, then they can't use it in trial. So that's what he's trying to do right now. And Mr. Hoover is doing a good job, okay? Y'all got to give him his props now. He is out here defending his client, and I think he is doing a decent job with the facts that he has on cross-examination. How he started out establishing, hey, you're a police officer, and you have to memorialize everything, and you have to be truthful, and you have to be truthful and accurate, and you have to put everything that's important inside these reports. And if it's not important, you don't really put it outside of that. You don't leave it outside of the report. So everything in here, what you thought was important, you put in here, and you were truthful on that day, and you're going to be truthful on this day. And all of that establishment in the beginning is for what he's doing now, which is you never put this in the report. You never put that in the report. You never put this in the report. So basically, he is like, all this information you're giving us now wasn't even in this police report. So now all of a sudden, why is it so important? So, he's doing this thing on cross-examination.
Officer Ivan Yevtushenko, do you remember a conversation between him and Mr. Williams where Mr. Williams repeatedly said, can I call somebody to move my truck?
No, I do not remember that.
Do you remember a conversation where that officer said, don't worry about it, we'll let you make that call?
No, I do not remember that.
Did you have body cam on that day?
Yes, I did.
Have you reviewed the body cam since you've been here?
Yeah, it's been a while.
Okay. But you don't remember that conversation?
I do not.
Okay. Now, the vehicle, as you stated, was impounded, correct?
Yes, it was.
Mr. Williams was never allowed to make a phone call to get somebody to pick up the vehicle, right?
It's per our policy. Once someone is taken in custody, they're not using the phone.
So, neither yourself or the other officer gave Mr. Williams the ability to get somebody else to pick out or pick up this illegally parked vehicle.
So you guys hear this. This is what I'm saying. The vehicle being removed, he has established it wasn't blocking traffic. It wasn't in the property owner wasn't saying, come get this vehicle. He wasn't obstructing anything. There was no reason to believe it was drugs or you smelled drugs on him or anything that would be in there in the vehicle that you had to impound this. You could have called the owner of this car to come pick it up. Because oftentimes they will say, if they find out you're not the owner of the vehicle, they will say, allow you to call somebody to come pick up the car in order to not have it impounded. So he's arguing that this car, there was no reason, this was a legally parked vehicle, and there was no reason to basically tow this car. Is what he's saying. Because the towing of the car is what started everything else that happened thereafter.
Transported Mr. Williams, and within a few minutes it was stated that the vehicle was being impounded for investigative hold. So there was no need for a phone call because it was coming to PD for an investigative hold for a search warrant to be obtained.
So the answer.
And she's arguing basically that there was no need to call anybody. We don't care what he was talking about. We already knew that it was going to be impounded for an investigative hold. That was going to be the reasoning for it.
No, neither you or the other officer gave Mr. Williams even the opportunity to get somebody else to get that legally parked vehicle.
We weren't giving you an opportunity because the vehicle was coming for investigative hold.
So the truck gets to the impound lot. And as you stated, Mr. Williams wasn't arrested for any drugs or drug-related objects, right?
Correct.
No one said he ever smelled like it, he had it, or anything like that. Correct?
Correct.
Okay. So the truck gets to the impound lot, and Detective Gooden requested Officer Corey D-O-V-E-L-L to bring his drug sniffing dog.
That is correct.
So, no evidence whatsoever of drugs, no evidence whatsoever of drug-related objects, but a drug sniffing dog comes to this vehicle.
Yes, I will say to you, anything to do with that, you will need to speak with Detective Gooden on. That was his call, and I cannot speak for him.
And before that drug sniffing dog ever came to the vehicle, you didn't go into it and say, you know what, I have a probable cause to get into there and start searching.
I wasn't going into a vehicle without a search warrant.
So
As I said before, Detective Gooden at that time was the lead investigator, and he is the one who would be able to speak towards any kind of drug that can also come into that.
So before that dog came to sniff that vehicle, neither yourself or any other officer was like, I have enough probable cause to get in that vehicle and search it.
As I said, you'll need to speak to Detective Gooden on that.
To the best of your knowledge, you don't know.
I know that we had probable cause to get into the vehicle off of the investigation that we had. However, as I stated to you, Detective Gooden was the lead investigator on that. I was on patrol and very much in a learning capacity, so his decision on that.
Hold on 1 second, y'all. I got to take one brief break. Okay.
You will have to ask him what his decision on what he chose to run the dog.
And we'll talk about his decision. What I'm asking you is based off of the information you have. You know for a fact that no officer went into that vehicle with probable cause to search before the dog showed up.
I'm saying the vehicle came to the lot. It sat there waiting for a warrant to be obtained.
I want to jump back a little bit, but before I do, you memorialized in your complete and accurate report that dog alerted or hit on drugs in the vehicle, correct?
Yes, it did.
But you know, based off of the investigation, drugs were never found in the vehicle.
Yes, we never found drugs in the vehicle.
And you know that based off your investigation, drug-related objects were never found in that vehicle.
Correct.
Now, I want to jump back just a little bit, and this may get to a point where we have to play your body cam, but in your specific body cam, Do you recall the exchange between Officer Yabashenko and Mr. Williams, where the officer said, "Do you have anybody to come get the vehicle?" And Mr. Williams' response was, "Yes, let me call somebody first." Recall that? Right after that, Mr. Williams said, hold on, I need to call somebody." You recall that? Right after that, speaking to the same officer, Mr. Williams said, "I need to call my people real fast so they can come get my truck." You don't recall that either? Okay.
This doesn't sound like these body cams he's talking about was her. She might not even been next to these people, or we don't know where she would have been in order to hear this. So yeah, this is very interesting. So apparently what it sounds like is Nesto was like, "Hey, can I call my people to come get the truck?" And perhaps he was under the impression that they were going to allow him to call someone to come get his truck. And then somehow in between they decided to just tow it. So they're trying to challenge that for those that don't know or is just coming in. It's over 1900 of you guys in here. Make sure you hit the like button again. Thank you for helping me to meet my goals. I probably said another one of super chats. I appreciate all the love, and we shall continue. Subscribe to the channel too if you haven't done so.
Based off of your body cam, after Mr. Officer Yabashenko and Mr. Williams had that conversation, you actually said that you'll definitely let Mr. Williams make that call or something. You don't remember telling me?
I honestly don't remember.
Okay.
Well, there goes that theory. Apparently, he's saying that the body cam shows that she said she was going to let Mr. Williams make that call for somebody to come get this truck. Wow. Okay.
Do you remember a little further in your body cam, Officer Yabashenko said that they are going to lock the car down for now, go down to the station, and we'll let you make a call there? Remember that?
I do not remember that.
Okay.
I know we locked the car.
But you don't remember any of those times that you and Officer Yabashenko told Mr. Williams that you would let him call somebody to pick up?
I don't remember. To be honest, I was trying to keep a man safe in my custody and get him transported to the police department.
Was he not safe?
He was safe. I was saying that he was my responsibility.
So Mr. Williams gets taken down to the police department and Officer Gooden shows up, right?
That's correct.
And are you aware that Mr. Williams asked Officer Gooden that he needs to call somebody to pick up his truck because he was told by the two of you that he could?
I do not remember that conversation. I know that as I got to the police station, the one thing I do remember, and the first thing was we need a vehicle for investigative purposes.
So you don't remember any of the times that all three of you officers told him that he can have somebody come pick up the truck?
I don't.
So Mr. Kroll, as you say, came to the police department June 9th of 2022.
So honestly, the question is, does he absolutely have a right to call someone? Do they have to call someone if you didn't have any visibility of drugs or didn't have any in the car or wasn't blocking traffic? Or can, like she said, we believe that we want to put in an investigative hold because we believe it might be information in here. We looked in there, we saw suitcases, we saw bags, and we wanted to put it on investigative hold until we got a warrant. So he's really challenging, like I said, about there was no reason for you to even tow unless they go with, you guys promised me that you were going to allow me to call someone. That really isn't an argument because, to be honest, police officers lie all the time. And I've actually had a police officer on the stand that will tell you, we lied to you during interrogation. We have the ability to do that. You're innocent until proven guilty in this Justice Department when you get charged. But when you sit here in this police interrogation room, you guilty until you prove yourself innocent. And therefore, we'll lie and say we got 50 people that said you did it. They have the ability to lie, and case law allows them to lie. So their honesty in anything doesn't necessarily, when it comes to that, when they talk to the different people or talk to the suspects or whatever, really don't matter at the end of the day, because they lie all the time.
Yes. All right, and then Mr. Williams was arrested July 7th of 2022, right? And then the vehicle was searched the next day, July 8th of 2022, correct? You never memorialized anything in your complete and accurate report that you had probable cause to go out to search 980 Pine Grove Road before Mr. Williams was arrested, did you?
No.
And you never wrote in your complete and accurate report that you received information from anyone in Roswell PD or anyone in South Fulton or anyone in Henry County that they had enough probable cause to search 980 Pine Grove Road. Is that correct?
Yeah, I mean, it was an ongoing investigation.
And you never memorialized anything in your complete and accurate report that you had enough probable cause to search 990 Pine Grove Road before Mr. Williams was arrested.
I'm going to object on the grounds that, as the court instructed in the beginning, this was limited to the scope of the vehicle search, so not quite sure why we're getting into the residential searches at this point.
Okay. Let me get there. So Mr. Wood, maybe I heard wrong. What's the address? I've heard 980, 990. What's
There are two.
Oh.
980 Pine Grove Road and 990 Pine Grove Road.
all right? What's your response to the
Well, my response, Your Honor, is the state literally spent 20 minutes talking about all these different residences and all these different vehicles and what information they did or did not have. I'm literally narrowing down exactly what she put in her complete and accurate report regarding all of these different residences and vehicles she and the state spoke about. They literally spoke about it. Now they're saying, well, we don't want Mr. Wood to talk about it now.
All right, I'll allow you.
Thank you, Your Honor. So my last question, you never memorialized anything in your complete and accurate report that you had enough probable cause to search 990 Pine Grove Road, did you?
We did have enough PC to search. We got search warrants for 980 and 990, so there would be PC and a judge signed on that.
Before Mr. Williams was arrested.
At that time, we weren't getting ready to do it at that point. It happened that Mr. Williams drove down the road on that day. It was an ongoing investigation. I'm sure, as you know, things change in cases all the time.
So the answer is no. Between June 9, 2022 and July 7, 2022, you never memorialized anything in your report indicating that you had enough probable cause to go into that residence before the arrest. The answer is no.
It's an ongoing investigation.
And you never memorialized anything in your report that anyone else in the Roswell Police Department or in South Fulton or in Henry County told you, hey, we have enough probable cause to search 990 Pine Grove Road before Mr. Williams was arrested.
It was an ongoing investigation, and there were active warrants for his arrest.
You never memorialized anything in your complete and accurate report that you had enough probable cause to search any storage units before Mr. Williams was arrested, correct?
Yeah, but we didn't have any storage units before he was arrested.
And so you didn't have storage units before he was arrested. I'll have now.
So I'll sustain the state's objection on storage units. That's relevant to this issue.
Thank you, Your Honor.
So what you will notice when you watch these cases is these police officers are very comfortable and familiar. And if you watch YSL, you saw that as well. They get very comfortable with the state because they work with them all the time. What gets them oftentimes is they get attitudes and they change their dispositions when it comes to the defense, because they know the defense is basically, obviously defending who they're trying to help put in jail. And they have to learn, it's an art for you to learn how to remain calm and still be respectable on both sides and not look like Because at the end of the day, everybody should want justice, whether you're a police officer, whether you're a prosecutor, or whether you're a defense attorney. Everybody should want justice at the end of the day. And we should all have the same goal. It shouldn't be to just win. It should be that justice be served. And that's an issue that I think a lot of officers and detectives have, is they get real comfortable with the state, where they know the state isn't going to try to trip them up. The state is just trying to, and what happened next? And then what made you do this? And how long have you been an officer? You know, it's like a conversation on the phone. Defense is going to hold your feet to the fire. Like, you didn't put that in the report, right? But that's what you said that you do. You memorialize everything that's important. Is that correct? Like, they're going to cross-examine you and basically hold you to yeses and nos. And that's what makes them want to explain for 5 minutes and all of that stuff, like we may have seen in the YSL trial. So that is one of the things that does occur that you guys have noticed, is that the demeanor in a lot of these people, these officers or detectives, change when it's on for the defense, because they don't feel as comfortable, and they know what the defense is going to try to pick apart how you did your investigation, pick apart how you're not as great as you're trying to hold yourself out to be. That's what the job is, you know. So they know what the job is, and so they do get frazzled. You'll see their face get flushed. They'll start getting a little irritated, and I think some of you guys have noticed that since she's been on since cross-examination occurred.
And just so the record's a little clearer, Ms. Delaney had her interview on 9/15/2022. Does that sound about right?
Yes.
Okay. And Ms. Washington had her interview on 8/27/2022. Does that sound about right as well?
No, that sounds about right.
So he's saying the interviews of Miss Delaney and the other individual that they mentioned did not occur until September 15th of 22, which would have been what? Couple of months after his arrest, and August of 2022, which would have been a month after the arrest. So even though you're saying, you know, you may have interviewed her before per Wooten, you didn't really interview her, regardless of what you're saying. This alleged investigation happened 30 days before the arrest. You guys really didn't interview her until after he was arrested, is what he's trying to establish.
That's the right answer to the question.
Read right.
Just very, very briefly, Detective Fields, we kind of use the word impound loosely, and you make reference, I think, in testimony and in reports and other places to the word impound. But can you explain the difference between an impound, like just a pure impound, like because the car's in the roadway, versus a seizure for the purpose of getting search?
Okay. So just, we use the word impound, which means we are taking someone's vehicle, and either, depending on what that purpose is for, it will depend on the location that it goes to. So if we are impounding a vehicle because it's in the roadway, but we have no reason to get a search warrant or anything, we will have the tow truck come. They will pick the vehicle up, and it will actually go back to the location, American Towing in Roswell, which is where all of our vehicles go through for impound release. If it is being brought back to the police department due to the fact that there is an investigative hold on it, or it's coming to be processed by CSI or whatever the parameters are in that regard, it's still an impound. We are still taking the vehicle, but instead of it going to American Towing, it is brought to the police department, which is behind a secure fence. So that way we can control the area that it is located, so that no one is tampering with it, or if it needs to be put in an evidence bay to protect any kind of evidence. So that's where the difference is. So it's an impound, whether it's just impound for release or an impound for investigative hold or evidence base.
So in this case, was it an impound for release or impound for investigative?
It was impound for investigative hold.
And when a vehicle is being impounded for investigative hold, is it of any relevance that someone, the arrestee, wants someone to pick it up?
It doesn't matter. At that point, it's being seized, impound for a warrant. to be obtained to go into that vehicle. And the reason you wouldn't call someone is because one, the vehicle can move. So at that point, it's an exigent circumstance. And so whoever had the extra key for that vehicle, who we have no idea about, came and got that vehicle, they could have gotten rid of all the evidence that was in that. So no, that you do not need to give anyone that the ability to call. However, if we were impounding for different reasons, that the car was just going straight to American Towing and that it could be a release, absolutely you would get a phone call to be able to call a family member or the owner or whoever to come and retrieve that vehicle. And again, it was on private property, so for it to stay, we would have had to have permission for that vehicle to stay there, otherwise it needs to go.
Is it fair to say that part of the reason for seasoning, bringing it to the police station is to preserve it from someone else tampering with it?
Absolutely.
Keep, make sure someone doesn't break into the window and take things out of it?
Absolutely.
I want to go to the questions about your police report and memorializing the moment you determine you have probable cause. Is it your common practice when conducting an investigation that involves search warrants that each time you determine, hey, now I have probable cause for a search warrant, memorialize that in your report, or do you just go get search warrant?
It depends. So every case is different. And so, again, timing also plays a part in that. So if you're working on an investigation and you have PC to go, doesn't mean we have to go right then to go get that search warrant. Maybe we're trying to do something different. Maybe we are trying, still to get other information before we go. And sometimes things happen, such as Mr. Williams driving down the road on July 7th and happened to drive by me with active warrants, and I arrested him at that point. That was my job as uniform patrol. You have a warrant, you're going to jail. And unfortunately, we were in an investigation, and at that point we did have stuff, but maybe at that point Detective Gooden didn't feel that it was necessary up until we got the arrest that we should go ahead and press on with the search warrants.
And then I want to go back, there were some questions on cross about your noting these other active warrants for this notice at in your report. Did you note those warrants in the report?
Yeah, they were noted, and they're noted at the beginning of the report.
And say beginning, they're above, fair to say they're above the part we talked about the July 7th arrest?
Absolutely, yes.
So if you read through your report from page 1 to the July 7th arrest, fair to say that you will have read about those active warrants by the time you get to July 7th?
Absolutely.
No further questions, Joe.
Yes, Mr. Lee. Yes, Your Honor, I do have a couple of questions. Officer Bill, you said something interesting that I have to ask you. You said one reason why you impounded the truck was because if someone else who had another set of keys, you said they could have gotten rid of all the evidence that was in that truck. That's what you just said to the state, right?
Okay, yeah, if there was evidence in that truck, then yeah, it would have been, someone could have gone in and taken it. And even after the fact, there were phone calls between Mr. Williams and his son, Dion, as well as Lamont, talking about, you guys got to get that stuff out that truck, get my stuff out my truck. And he was always sending people to do things for him. Yes, maybe that was after the fact, but at the end of the day, if someone has something in that vehicle, you very easily want to get rid of it. You can have someone come do that.
So you admit there was evidence in that truck?
We call it evidence after because we found that after the fact through a search warrant. I said as evidence, let me rephrase and say, there were items in a truck that could have been removed that at the time could have been evidence, they could not have been evidence. However, we obtained a search warrant and found evidence.
So it would be a misstatement standing in court today telling the judge there was no evidence in that truck involved regarding this investigation.
I'm sorry, repeat that.
It would be a misstatement to stand in court today telling this judge that there was no evidence in that truck that's involved in this investigation.
There was evidence in the truck.
Thank you. Now, you testified earlier about Mr. Williams at the police department. You and Detective Goodman are there, and he asked you to go to the truck. Remember that part?
To go to the truck, his truck at the police
It was
station.
already impounded, yes.
Yes.
Okay. Do you remember the exchange between you and Detective Gooden where you said, I guess so, I need to get a search warrant for that car? And then he says, yep, 100%, need a search warrant on that car. You said, the phone's in the houses too. You remember that?
I don't remember the exact details, but I know we had a conversation talking about it. And as I stated earlier, I was a patrol officer, so I was very much in the learning phase. So me asking that question was looking to someone who had more experience to say, as an investigation goes on. I think we all do that when we're learning our job.
And after that exchange between you and Detective Gooden, you didn't get a search warrant first. Y'all got a dog to go sniff there.
Again, I'm not going to speak for a dog. You can speak to Detective Gooden on that.
I'm not asking you to speak for the dog. I'm asking you, right after the two of you conspired and saying, hey, we need to get a search warrant for the truck, the phone, and the house, you didn't. You went to get a dog first.
Yes, and so as I said to you before, you can ask Detective Gooden on that.
Your Honor, may we approach? Yes.
My. So I think she is the one that is supposed to be on those other cases that have not been indicted yet. So we'll see. Make sure you guys hit the like button, subscribe to the channel if you have not done so. They are approaching the bench right now, and I'm assuming they're going to end up playing the body cam or something like that, but we shall see. Yeah, it looks like Winfrey to me. It's like, I didn't order the dog. Look at her trying to ear hustle. She's like, what are they about to do next? Look at her face. She got her feeling really uncomfortable. What she is saying though, which is true, is she's saying that she is saying that we had probable cause before for the houses and all of that. That doesn't necessarily mean that we didn't have it before we got the car. He's trying to connect every piece of information to the car, which I think will be difficult to do.
I understand everything is going.
Okay, let me go back a little bit. I was trying to get past the.
Sometimes there are conferences at the bench, that this is your case and you have a right to be present for anything and everything that happens at the bench. But you can also waive that right. So I will let Attorney Hoover talk to you about it, but I guess my question is, do you have any objections to us having the bench conferences? If we have a bench conference, we will make sure that after the conference, your lawyer discusses with you what was discussed at the conference so that you will know what happened. Otherwise, we will not have bench conferences, and we'll do whatever else is necessary to make sure the objections and all are heard. But I guess my first question is, do you have any objections to us having the bench conferences without you being present, and then informing you, letting you really inform you of what happened? Yes, you have. Okay, yes, you have an objection, or yes,
Right.
you have a bench conference? You have. Okay, we can have the bench conference. Okay, then I'll find that Mr. Williams has waived his right to be present during the bench conferences. And Attorney Hoover, have you informed Mr. Williams what we just discussed?
Yes, Your Honor.
Okay. So, Mr. Williams, are you comfortable that you understand everything that's going on with these proceedings today?
Yes, Your Honor.
All right. If Mr. Williams, if at any time you have any questions about what's going on, or you think you've missed something, please let me know. It's my intention that you understand that you are a part of everything that happens in this case. I know it's also Mr. Hoover's desire for that to happen. But I've sent the Zoom link to the parties. So, Mr. Hoover, if you are ready, we may continue.
Detective Fields, you did testify earlier that you did have body cam the day you arrested Mr. Williams, correct? Your Honor, at this point, I would like to play the police exhibit 1, which is the body cam footage of this officer the day she was.
All right, anything from the objection on this case? All right, you ready? Play the relevant portions.
Yes, Your Honor.
Let me take my phone back.
Mr. Williams, how are you doing? Can you go ahead and turn around for me, sir? You're under arrest. There's a warrant for your arrest. Yes, sir.
Yes, sir.
Brother 1-1 custody. That's okay. I need to. Sorry. I'm trying to fix it for you. Okay, can I fix it for you? Okay. Can you turn your hand up? Can you turn your hand this way for me? Twist your arms to your palms are facing you. There you go. Thank you. It is. I know who you are. You're Earnest Williams. Okay. And Nesto is like that. I know exactly who you are. And there's a warrant for you out of Roswell. There's a warrant for you out of South Fulton. Yes, sir. We're just not. Turn around for me. Can you grab the belt for me? Okay, we'll definitely do that. We're gonna stop by the station first, okay? Do you have where your keys at? Do you have the keys, Ivan? Okay. Yes, I know it's an active one. Yes, sir. Yeah, it's our warrant. We have one out of Roswell for you. It's an active warrant out of Roswell. For theft by deception. Okay? Yes, sir. Hold on, while you have that, I need it plugged in, because we may want to interview.
So I'm calling you at 3:32. And now do you remember that you and that other officer told him yes, because you can be calls and something like that, correct?
I'm gonna see if that's there.
And you never gave Mr. Williams the opportunity to make a call to somebody in the truck,
I
right?
mean, at that point, I was also trying to get him into the police station. Since number one for me. And at that point, I was until we were, when I talked to the detective in, that we were bringing him for investigative court. So at that point, the call is not on the call at that point.
So no, you never gave him the opportunity.
He didn't get it because he was coming for investigative court.
And the other officer never gave him the opportunity to do so, correct?
The vehicle was coming for investigative court.
Thank you. Now, you also testified that you went, you and Detective Gooden, when the truck was impounded, that you two went to the vehicle because Mr. Williams actually was there, correct?
Yes.
And Your Honor, this will be marking with this body cam footage while at the police department going to the impounding.
Yeah, I mean, I'll go in today and tag, I'll leave that, I went in to tag the interview with Cole the other day too. So, what did we say it was, in this little bag? I'll just take that, I guess.
Okay. Hey, you see the keys in there? You see the consoles? That glasses.
Oh, yes, the keys.
Okay, what you do?
Leave them right there? Okay. So, okay, that's fine. Yeah. Let's take that out and then I'll put that into evidence too. And then I guess, so, need a search warrant for that car.
Yep.
100% need a search warrant on that car. Bonds and those houses.
Okay, so now it looks like they're going into closing arguments. It may have been a little bit that was missing towards the end. They just basically probably asked her, now do you recall saying all the stuff about you need a warrant, definitely need a warrant for this car. So now he's over about to do the closing arguments. And because this is his motion, so he will go up first. The videographer, he said his battery was running a little low. So so it might be a little snippet that's missing, but for the most part, it's all here.
No, Your Honor, in the state of Georgia, we have the exclusionary rule. The primary reason for the exclusionary rule is to deter police conduct, whether it be negligent or intentional. And that comes from State v. New NEW 331 Georgia Act 139 2005 case. When evidence is obtained in violation of the Fourth Amendment, the judicially developed exclusionary rule usually precludes its use in a criminal proceeding against the victim of the illegal search and seizure. The purpose of the exclusionary rule is to deter unlawful police conduct and thereby effectuate the guarantees of the Fourth Amendment against unreasonable searches and seizures. Now, since Mr. Williams has a Fourth Amendment, has Fourth Amendment standing here, Your Honor, there are a couple of exceptions to the Fourth Amendment that I want to speak about because the state has the burden to prove to you that one of these, or A, that the search is legal, or B, that one of the exceptions applies. So the first one is the automobile exception. There's been no testimony regarding any automobile exception. It also does not apply here. The second is an exigent circumstances exception. In their response to my motion, they didn't say anything about exigent circumstances. However, this witness did say she used the word exigent. I don't believe she actually said what the exigent circumstance was. So I don't believe there's any testimony whatsoever that it applies in this particular case for this particular search. There is no, in Georgia now, there is no state statute governing procedure exception. We used to have that, but Gary v. State, Gary v. State 252 Georgia 573, a 1992 case, says that that's no longer good law here in Georgia. And under Georgia as well, we no longer have the good faith exception. Abercrombie v. State, 343 Georgia App 774, 2017 case. Again, Gary v. State, that I just quoted, and OCGA 17530, I'll go for the premise that there is no good faith exception to the Fourth Amendment in Georgia moving forward. Now, I do want to get into the inevitable discovery doctrine exception. That's something that the state could present. Again, there's been no, I believe that's where they're going to hinge most of their arguments on, the inevitable discovery doctrine and independent source doctrine. So the first case I would like to quote is Davis v. State. That's 262 Georgia 578, a 1992 case. We cannot allow the exception to the exclusionary rule to render meaningless the warrant requirements of the Fourth Amendment. Inevitable discovery involves no speculative elements but focuses on demonstrated historical facts capable of ready verification or impeachment. I believe this case is really good for Mr. Williams' argument because, Your Honor, the state's going to get up here and say because there were ongoing investigations or we were looking into something else or other law enforcement agencies were looking at something else, then somehow they fall under the inevitable discovery doctrine. However, there's been no testimony. I'm going to give this a little more. There's been no testimony based off the only evidence the state presented. All they had was ongoing investigations. That's not enough to get, it's not enough to allow the state to violate a person's Fourth Amendment. That's not enough by itself to get somebody into your house, to get somebody into your vehicle, to get somebody on your person, to get somebody to go into any type of personal electronics that you have. There needs to be more than, well, investigations were happening. As we know, Your Honor, and I'm going to get into the timeline a little more, but as we know, at no point before Mr. Williams was arrested did they have, or what they believe, probable cause to go into those homes or to go into the electronics or to touch any of the vehicles. So the state has not presented any evidence of the inevitable discovery doctrine exception. There's also Mobley v. State, 307 Georgia 59, 2019 case. This court has explained that for the inevitable discovery exception to apply, there must be a reasonable probability that the evidence in question would have been discovered by lawful means, and the prosecution must demonstrate that the lawful means which made discovery inevitable were possessed by the police and were being actively pursued prior to the occurrence of the illegal conduct. Again, I'm going to get into the evidence that was found in the vehicle, because now we do know testimony that there was actual evidence in that truck. But I'm going to get into that evidence to further point out how they couldn't get to anything else until they got the materials and the electronics and the evidence that they found in the truck. Mobley also says, the mere fact that the investigator obtained a warrant on the following day is not enough to bring the case within the inevitable discovery doctrine. So again, there was a lot of testimony, well, we could have done it. Well, that's not enough, Your Honor. The state has to show more than just, we could have done it. So that takes me to the independent source doctrine exception. The first case I would like to quote is Tatum v. State. That's 319 Georgia 187, a 2024 case. And this court is quoting a rule from Murray, M-U-R-R-A-Y. If the second lawful search was not prompted by the prior unlawful search, then the independent source doctrine applies. And the state is in the same position it would have been in if the unlawful conduct had not occurred. But if the second search was prompted by the original unlawful search, then the evidence must be excluded so that the state does not benefit from its unlawful conduct. Under such circumstances, the independent source doctrine should not and cannot apply. Now, Your Honor, the second searches we're talking about, with second, third, fourth, fifth, deals with the residences, deals with the storage unit, deals with the vehicles, deals with the electronics. All of that happened because of the first search. It's a legal search of the truck. The state has presented no evidence whatsoever that officers, any of the law enforcement agencies that they talked about, ever had enough probable cause to get a warrant. It's actually the opposite. They were still in a pending investigation. None of the officer tried to say that they had enough and they were going to do it. Your Honor, there's no evidence of that at all. The only evidence is active investigation, and all of a sudden this one thing happens. Oh, and now we can get into the houses and the residents.
The difference, and I do believe the Reyes-Castro case is very instructive. The seizure of the truck, I believe the officer had a hunch that there's something in that truck, and they're not allowed to have hunches. Officer never saw any crime being committed involving that truck. The officer never saw the defendant put anything relating to the crime in that truck. She never saw him deliver the bad check in that truck. The vehicle was not stolen. The briefcase and the suitcase, she never saw a document in that truck sitting on the briefcase talking about anything. She had a hunch that there's something in that truck. And I believe her testimony was such that she believed, she has had a hunch, a belief that there's something in that truck. And they needed to investigate what was in that truck, because there could be something in there, but there could also not be something in there. So I think she had a hunch as to there could be something in that truck. There was no evidence to lead to any probable cause to believe that there was anything inside the truck other than the defendant was driving that truck that day. And if that truck should not have been seized under the Reyes-Castro test because there was not probable cause, then we never get that truck to the impound lot, and then the dog never incorrectly hits on the truck. Maybe the dog needs more training, maybe the canine officer needs more training, but then the dog, the canine officer never incorrectly alerts on the truck to get inside of the truck to not find the drugs, but to find other things in the truck. But I do want to read through the cases cited, but I also don't want to miss this opportunity to determine if this is a hunch, and Mr. Hoover, this is for you, if this is a hunch and the truck should have stayed there in the parking lot, if that is my ruling, then I think the real question becomes, I understand the things found in there that's in the return of the search warrant 030244, the book bag, the silver and black computer, cell phone with black and white iPhone with black and white cover, the 32 gigabit USB drive, and the keys are all out. But then, that leads to the bigger question of where does that take us? What other evidence does the defense believe is connected to the excluded evidence? And what other search warrants does the defense believe were only gotten based on the excluded evidence? And that's kind of why I had you go through the list of things, because I do believe the state was not given proper notice of the poisonous fruit from the tree. And so I would like to hear more on what else would be excluded and how those things are connected to the items found in the truck. Now we at least have a list of items, the search of the residence, the computers, the iPhone, those seem directly related to the truck there. The defense also believes there are some other items that might very well be excluded, that I would give the state an opportunity to bring forth evidence if they need to file a reply. I guess the defense needs to file something and give the state an opportunity to file a reply. I would like to issue one order versus two separate orders. The reason being, because if I'm going to suppress some of the state's evidence, they have an absolute right to appeal, and I would rather do it in one appeal, Mr. Wu, than take this issue up, and they say, okay, Judge Dunaway, you were right on this issue, and then after we do the second issue, because Mr. Williams is in custody, I would like to get it up one time for the Court of Appeals to tell me I'm wrong, then go up once, they say I'm right, and go up the second time, they say I'm wrong. So if you all would, Mr. Hoover, if you would please give us a more particularized motion on the other documents and the evidence that you believe is excluded from, I got the truck part, right? I got the truck part and the return of this warrant. I'm kind of with you on that, but what's the next step past the truck? I understand you got the houses, you believe, and anything else you believe that maybe needs to be looked into. And then for the state, I want to give the state an opportunity to bring forth any other evidence, witnesses that you believe why these things are not connected to the search of the truck. And I will, I know we're about to hit a couple of week break with the holiday coming up. So we have to find room in our schedule to have another hearing. But I guess, Mr. Wooten, how long would you need to get something filed on the fruit of the poisonous tree evidence? I'm sorry, I was looking at Mr. Hoover and I said, so Attorney Hoover, how long would you need to particularize the second part of your motion? And I think you have all the information clear, you just need time to get it together.
Yeah. Only because of the holidays next week. If I get 2 weeks, it shouldn't take that long, but just because of the holidays, I asked for 2 weeks.
Okay, and that's fine. I'm gonna give you the time you asked for, but keeping in mind that, we do have Mr. Williams in custody, and then the Court of Appeal, if they wanna look at it, it's gonna take them some time. So, let's say, January 6th.
Okay, so that is the end of our video. I'm mad I missed what Wooten had to say, but it sounds like based on what the judge has said, is that he's leaning towards the fact that you basically had a hunch and you didn't have probable cause based off you didn't know if it was evidence inside. Now, she testified a little bit differently than what she did for the case that I heard, the preliminary examination, because she said she knew, she was told by people that she talked to that he carries his information within that vehicle. She said that before, that he keeps all his documents on his person. He's always the one with that vehicle. She didn't say any of that in his testimony. I don't know why she didn't say it, but she did. So what it sounds like is you really didn't have probable cause to move this vehicle in the first place. And it sounds like based on some factors or a case that he mentioned, which I didn't get the full cite, the judge is leaning towards that perhaps you really should have never taken this truck in the first place, which means if all these warrants were premised off of information in the truck, which I didn't see what the affidavits were saying, but you had this dog that I don't know why the dog was called. I agree with that, because it's like there was no type of notion that he was some drug dealer or that he would have it on him. So that was just weird, unless your dog doesn't know what the dog isn't trained properly, and they would have did a hit, which would have gave you, if that's their probable cause to get in the car, then I agree that is a problem. You know what I'm saying? Like if it was anything that had to do with the dog. But again, I didn't see any affidavits for the warrant on what facts that they gave in order to even get the search. Then they got the body cam of Detective Field basically saying once she went in there to get the medication and she took a gander of what was inside the car, she's like, oh, we definitely need a warrant. We definitely need a warrant. The stuff that she was caught saying on the body cam. But again, in my opinion, generally, just based off the information that we have, that would affect more of the CP charges, because that laptop was in that truck. It would affect, I think, the other case more, not necessarily the SA cases, because apparently it's supposed to be a young lady that came and they gave this information. But the CP charges, it would definitely affect that, because it would, everything that they would have gotten, the warrant for the laptop, all of that would be fruit of the poisonous tree, and it couldn't be included. It would be suppressed. So the issue that we have, though, is that, again, Wooten is saying we had all this information prior to, even though the interviews may have happened after the fact, we knew about these people because there were warrants long before. So that's not going to affect the bulk of our case. He doesn't need whatever was in the truck. But again, in my opinion, based on what the information I have, I feel like Winfrey should have not, Winfrey in her case, if she decided to go forward with it, she would need that information, because the warrants and all of that for the laptop all would have precipitated from that initial taking of the vehicle. So I'm kind of confused, because the little clip was missing on investigatory hold and all the extra stuff. I'm sure there is a piece that I missed. So I'm kind of mad we didn't get that clip. If anybody was in there that can explain it, that would be great. But yeah, it looks like he might have, Hoover did his big one. I think he did a great job on how, with the facts that he had. I think he did a good job with it, and we'll see where it goes from here. But I do think, again, based on the indictment, I think that a lot of the information did come directly from witnesses when it comes to his case. That's what I gather from the information that I have. Let me see. This might be why he hasn't been indicted in the other case yet, because they knew they would have a problem. But see, they brought it up. The other attorney did bring it up in the preliminary examination. She challenged it. And I'm telling you that that detective, who was an officer at that time, Detective Fields, she said, because she was advised by other people that he keeps his documents in the car. And she said he keeps it close to him. She didn't say that on this one, but she said that in the preliminary examination. So we'll see. You said you hate the word memorialized. Well, he's trying to have the RICO thrown out on the demure. They're just doing that. Or I'm assuming you just came in. They're doing that based off of the pleadings. And so what the judge has ordered is, okay, just assuming that I'm going to suppress anything from the truck, tell me what evidence came from the truck that would affect this case. You can't just say everything because, again, we know there was an investigation prior to. They are arguing. I don't necessarily agree with the position that because they didn't arrest him, they didn't try to search the house until after he was arrested. That would necessarily mean that it came from the truck because, again, they had information allegedly prior to. So that's why I said I feel like there is a little portion missing, but it looks like the judge sounds like, I mean, we never know. He said he's got to read other cases to make sure before he comes out with an opinion, but it sounds like he is leaning towards, and he said it right now, it sounds like he's leaning more towards Hoover. You said she's problematic. She did kind of come up a little fast, but it's a small town. She hasn't even been a police officer that long, and she became a detective, you know. And for her to say, "Oh, I was just saying that because I was just an officer, so I was just saying that," as if ask questions to the detective. No, that body cam made it seem like you said, "Oh, we definitely 100%. We're gonna have to get a warrant." So I don't agree with how she was characterizing her testimony. No, the CP charges have not been indicted yet. They are still unindicted. I told y'all. I was like, it can't. I get it. Everybody's like, get it out of here, Hoover. No, this is his job. This is what you do. If you can find something that they did that was not done proper, his job is to find a case law to back it up. And I think that he did a decent job trying to back it up. Now it's up to the judge. And also, even if it is true and they decide to suppress it again, to me, when it comes to when it may put him in a better position if he wants to plead to some of the stuff, if he chooses to plead to it. It'll put him in a better position. They may drop the RICO. Look what happened in the YSL trial. They may drop it and say he did 2.5 years. He's already older. Maybe we'll give him time served or something. So, I mean, his attorney is doing his job, and I think he should. We got to give him credit for doing his job. He's supposed to defend his client. But he still has the SA charges as well. And again, based on what I've read, it has nothing to, I mean, they've come against the girl's credibility and all of that stuff online. I seen that they done looked on her pages. They know when she ain't here and all this extra stuff. And then there was some outcry allegations from certain people. And he's challenged the credibility of them online. So, but again, as they said, there were a couple of warrants that were already out, even in California, involving theft and all of that type jazz. I believe Nesto said something about the California stuff was already somehow resolved or something. I don't know. I can't remember. I believe we talked about it on the phone call. But California has said they're not trying to get them. So they ain't trying to take, they're not coming here to get them. It ain't that deep for them in California. So, okay. You have to have probable cause. That's why I said it's a part of this that's missing, but it sounds like the judge, based on the information he got, said, listen, she says she has a hunch, and you can't. Now that is true. You cannot get warrants and search cars based off of a hunch. It has to be probable cause. That is what the standard is. And it's a very low standard that a crime was committed and you did it. And apparently anything that had to do with the car, this was there was no information. He said, this is what the judge said, that some documents was sitting on top of something and you saw it. That's why Phil should have kept with the same testimony she had in the other case, where she said, well, I was advised by people that I interviewed because I was investigating, unless somehow she said that and it was somehow after his arrest or something. But if it was before the arrest, when she was doing her alleged surveillance and all of this stuff of the property, if she was told that he keeps it in this vehicle right here, in this white 350, 3F350, and that's where he keeps it in a specific bag, and you saw on plain view that there was a specific bag in there, then yeah, you may have had probable cause. But she didn't like testify to any of that. So you said she's going to watch the hearing on Monday. So, but anyway, yeah, she said she basically was like, it could have been evidence. And she admitted it. Like, I didn't know if there was evidence in there or not. She said that. Like, she looked like, I didn't know if it was evidence in there or not. So, it's going to be interesting. Cindy White, I wonder what Sonia's going to say about the attorney. She better say he did his job. Shoot. And Sonia was talking about the warrants and stuff. She was, although maybe not articulating it very artfully, but she was talking about the warrants, and she was like, all of it should be suppressed because they shouldn't have never took the car in the first place, or whatever she was saying. I think she was arguing that on the phone calls. But again, as lawyers, that's one of the first things you do is try to attack the warrants, because if you can attack any of the warrants, he didn't attack the arrest warrant. He just was attacking the search warrant. But if you can attack it, then of course, anything that's fruit of the poison, that's considered bad fruit, poisonous fruit, then you can get it suppressed. And that may actually, again, there's been plenty of cases that have totally been dismissed once you want a suppression, because now they don't have any evidence against you. Like, say they found a phone number of a lady in your car, and that's your main witness. You're like, listen, you wouldn't even know this lady existed if you hadn't illegally searched my car. So if that's suppressed, then you're, all the information you received, unless you can show that you got it from an independent source. Now, I believe from the information that I have, as far as Wooten, I think he may have been able to get it from an independent source, obviously, because they had investigations before and they had warrants before. But as far as, like, again, the CP charges, I don't know how they would be able to argue an independent source, because they literally looked through the laptop after the search warrants. So Stacy said, I know that the landlord was glad he was arrested, got him out of the house. That landlord seemed like he couldn't keep nobody in that house. When I was looking up that house address, I'm like, then I seen like Earnest was attached to that address. It looked like even before all of this stuff happened, like some years ago. It was, I don't know what's up with that address. But yeah. Toya said, I always thought that having an active warrant was enough for a search warrant. No, you can have a warrant for their arrest. And then usually, like, for instance, if there's like somebody was unalived in a home, and you go in there and you look at the body, and then when you look on the table, you happen to see some cell phones or whatever, then yeah, that's probable cause for you to go try to get a warrant to get the phone records, or to do a phone dump, or whatever pertaining to the house. Or if it's money in the house or whatever, you're trying to grab stuff for fingerprints, that type of stuff, you can look at, not necessarily have a warrant yet until you look and you actually see stuff in plain view. And then you say, okay, this may be attributed to this unaliving or whatever. So, I mean, they found Melody S. credit card number in the passenger floorboard on a piece of paper. I remember that, but it sounded like they knew who Melanie Scretchen was before. They think he used that to use her card to make purchases at a car lot. They need this evidence for that. Well, they knew about Melanie. Now, one thing they did know at the beginning, she said she knew about Melanie Scretchen, is what it sounds like at the beginning, I think towards the beginning of her testimony. So Melanie could testify as to, she gave him a credit card information. She wrote it on a piece of paper. No, she gave him the credit card information. That was it. But as far as, like you said, if it's suppressed, then they can't say they found the credit card number, they found it on the floor. Like, they can't say that, which may help his case, because it'll look like, listen, we were in some type of relationship. She gave me her information and I did everything with permission. So it'll be a credibility issue on whether she just got mad because the relationship didn't work out, or whether he really took her stuff and went beyond her permission. But having it written on a piece of paper, I don't even know if that would even bolster the argument, because when she first gave it to him, he could have wrote it on a piece of paper. He could have did that initially when she gave him the information. So I don't know. I think when you have the actual live witnesses, and if he's able to do it, then, if he's able to have the live witnesses, then that's evidence within itself. But I think it will put in the most that they can get thrown out, the best position that he's in, if he wants to plead to anything. If he's choosing to plead to anything, he might say he want to roll the dice and he's going to fight everybody. He doesn't care. But I guess we'll see. Melanie signed a warrant in June. Per Nesto, Melanie told him that she filed a warrant on him. Yeah, that's what I'm saying. Melanie tried to do the warrant, and I think that's the case that or maybe it was Delaney. One of these cases, Erica King won for him. He was trying to get a warrant, and Erica King, let me see if I can pull it up. I gotta find it. I haven't looked at this stuff in so long. Regina Delaney. No, that was Delaney. She got an affidavit for a warrant. Let me see. Stop. Where's it at? So this was an affidavit for a warrant. Personally, who won Earnest Williams, a call between Earnest Williams accused between February 7, 2022 at 12 a.m. and February 7, 2022 did commit the offense of conspiracy to commit a felony. Hold on, maybe that's the wrong one. Hold on. And you guys were roasting him on his suit. You guys know you're wrong. Messing with this man's suit. Shoot, that's not important. He out here fighting for justice. This was from Detective Fields. And this wasn't signed till September. This ain't it. This can't be it then. Find application, affidavit for a warrant. Why this didn't? Oh, that just didn't come on my screen. Hold on. Affidavit. That's not it. Okay. Affidavit for a warrant. Hold on. I'm trying to find it. I know Regina Delaney has some stuff going on. Let's see. And then the application I know was denied. This was the one. So Regina Delaney, she tried to do a warrant. And hold on. And it was denied. And this was one of the ones. So this was a 21 case, and she did a warrant application. And this was when she was alleged. She was pro se, so she represented herself, and he was represented by April Holloway, aka Erica King. And they had in the above style action, the warrant application was filed on January 11, 2021. The court, having considered the pleadings and testimony during the application hearing on February 7th of 2022, and the application was denied. So she was trying to get a warrant based on that, saying her motorcycle was stolen. Let me see. Because I was like, shoot, Erica was out here winning these cases too. So then it sounds like maybe Fields, after the fact, she did do a warrant, maybe on behalf of Delaney, because Delaney is in. Oh, that's interesting. So she tried to get a warrant already, and it was denied, and Erica was representing him. But Delaney is in this, she's in this indictment. So on September 16, 2022, she interviewed Regina Delaney in regards to theft of her Harley Davidson. So she didn't interview her until after he was already arrested. But I think they would have an independent source because she had already previously filed with the court in 2021, I guess, saying that he took it. So the information she got was it had the VIN number it was taken by Earnest Williams, allegedly, who was a habitual violator of theft. And then it has Delaney met Williams in July 2020. Williams promised to help Delaney build her business and encourage her to buy multiple high-priced items. Delaney purchased said motorcycle in September of 2020 and originally stored it with Williams. Delaney paid for the deposit as well as the monthly payments. Delaney requested her said motorcycle from Williams, and she received said motorcycle from Williams on September 24, 2020. Approximately a week later, she said the motorcycle and her big Tex trailer were taken from her complex by Williams without her permission. Williams stated to Delaney that the maintenance man had called him and asked him to move it. Delaney never gave permission for the property to be removed. Delaney filed with Fulton County Court on January 11, 2021, in hopes of recovering her property. On February 7th of 2022, Delaney and Williams appeared in Fulton County via Zoom. Delaney was not represented by an attorney. Williams was represented by attorney April Holloway. During the interview with Delaney, I showed a screenshot of a previous Zoom on February 1st with Shirley Strawberry as the defendant, who was not in appearance. Instead, Williams appeared on her behalf with her lawyer, April Holloway, via Zoom in Fulton County. I asked Delaney if she recognized the female in the video, and Delaney stated that she recognized the female as the same attorney representing Williams. In civil action file number, Erica King was identified by an anonymous victim as well as by her driver's license picture. So accordingly, and then it shows about the whole information with Erica King. I don't think this necessarily helps the whole car situation with Erica King, because they got this is going to be very interesting. Simply Me said, is that the motorcycle he was on when he met Boney? Oh, I don't know. I didn't know he was on a motorcycle, child. I heard so many different stories. I don't know. Kay Slade said Erica is a far worse criminal than Nesto, excluding CP, and she's walking free. Okay. If a person is impersonating an attorney and wins a case, what happens with the disposition of the case once the impersonator attorney is found out? It's a very interesting question. So I've seen it where, from a criminal standpoint, there's been attorneys that have a person impersonated. There have been alleged attorneys who weren't attorneys, obviously, who impersonated attorneys, and they've lost cases and they've won cases, and all of those cases usually end up being re-reviewed. That's been my, from what I know from a criminal standpoint. But here, this case is all over the place. Erica says she's gonna test. That's a part of it. She has to testify. I don't know. I think he's gonna end up pleading out. That's what I think. I don't think he's gonna take this to trial. So that was the Delaney. So Delaney, there is information. So the warrants, though, they sound like they were for something totally different. Let me see what those warrants were.
50.
Williams, we had a gentleman come into the police department to follow up a report that their rent was not being paid for their property at 980 Pine Grove Road. That was my first time hearing Mr. Williams' name. After that, the landlord had stated that, you know, he had started renting the property in the beginning of March, and he, after getting a rent check that came back as insufficient funds, when he deposited it, there was also an air AC unit that was supposed to be replaced. That check also came back as insufficient funds. And he had done, as a landlord, he had done a check of the property in June, and he had said that basically there was no furniture in the house. It was very strange. Like, there was a Bentley sitting outside, an ambulance, and 2 motorcycles, and he just wanted us to look into it. So I did. So I went by the house. There was, in fact, a Bentley sitting outside. This is $1 million+ home in a very affluent area of Roswell, and there was a Bentley parked. There were 2 motorcycles and the ambulance. I ran the tags. The Bentley did come back to Mr. Williams, and at that time I was able to see that he had warrants for his arrest. One out of Roswell, one out of South Fulton. I believe it was Henry County, and then 2 out of California. All of them for theft, fraud, and I then ran the motorcycles.
Actually, let me stop you.
Okay.
Let's kind of go through
Yep,
some of this
sure.
piece by piece. So you said that Mr. Kroll, that's the victim who reached out to you, right?
That is correct.
Okay, and you said that was in early March of what year?
So he rented the apartment of March 2022, and Mr. Kroll came to the PD the beginning of June. I believe it was the 9th of June 2022 to make the report, because the money that he had received, the checks, when he deposited them, it had come back as not sufficient funds.
Okay, so is it fair to say that your investigation of Mr. Williams began on or about June 9th of 2022?
That is correct.
Okay. And just to be clear, is it your testimony that it began as an investigation into essentially some bad checks and potentially some fraud as it relates to renting a residence?
Correct.
Okay. And so from that point on, you kind of gave us some testimony about what you did. You went out, you observed the residents, you saw some vehicles. But can you kind of slow down and walk us through step by step with some timeline of each individual thing you did starting June 9th, 2022, and let's just go through the end of June, roughly.
Okay. So June 9th is when the report happened, or Mr. Cole came in. I went and ran the tags the same day, and that's when we had already been told that about the non-sufficient funds, the checks not coming back, and so then I found out that same day that Mr. Williams had warrants for his arrest. So then I started doing a little bit of investigation, and I ran the tags for both Harley Davidson that were on the property, as well as the ambulance. The ambulance came back to Nesto's Elite Private Security. So I started investigating Nesto's Elite Private Security. We were able to find an LLC, but there really was not anything tied to the business. It was just basically an LLC and then a vehicle that was registered under this LLC. And then I ran the tag. One Harley came back to a female by the name of Regina Delaney, and then the other one came back to a female, Olivia Washington.
So for those that asked the question, so when she ran the tag back in June, he still had that Harley Davidson, and it came back to Regina Delaney. So remember, this was in June of 2022. Yeah, we're in 2024. He's done like 2 years. This was June of 2022. She tried to get this truck back, this motorcycle back earlier that year, but Erica King was representing him. She was trying to get a warrant. And I guess the court didn't give it to her to try to get a warrant issued because she said he took her motorcycle and her trailer.
I want to take one step back first before
Yep.
we move to cars too. You said that you became aware that Mr. Williams had active arrest warrants, right?
That is correct.
What do you recall what those warrants were generally and what jurisdictions they were out of?
Yeah, so they were for theft and fraud, all 5 of them. We had one out of Roswell, which was theft by deception, I believe.
So he had one out of Roswell already that was theft by deception, and it was supposed to be, I think that was the veteran.
And that theft by deception, did you have anything to do with that case?
No, that had actually been a detective there, Detective Jackson, had pulled that warrant. I believe it was about a year or 2 years. It was during COVID, and he had taken money from a veteran and never followed through with the business.
Was that related to like a credit repair service?
Yes, I believe so.
Okay.
I don't know a whole lot about that case in the sense, but yes, that was Detective Jackson's, and it was to do with repairing credit.
Okay, so there's the warrant out of Roswell. What were the other ones?
So the second warrant was out of South Fulton, and that was for theft also, but that was for a vehicle, which was a lady by the name of Melody Scratchin.
So yes, you're correct. There was already a vehicle, a warrant. There was already a warrant for his arrest for a vehicle for Melanie Scratching. So that would have been before. So all of this information, honestly, to me, it sounds like they would have had independent information, at least as it pertains to the motorcycle and as Scratching, because they can testify to certain information and give it to the police separate and distinct from anything found in the car.
That happened, I believe, that was filed in the beginning of June of 2022, that he had taken the vehicle of another. There was then a warrant, I believe.
And we went over that with Scratching on one of the older videos, because we've been going over this case for a good year or so. And where she let him know that she was going to call the police and all of that on it. And he was like, I guess do what you got to do and all of that. So he was aware, he was at least aware that she had contacted the police. And there's other stuff with that case as well.
I believe it was Henry County, out of McDonough, that there was a trailer that he had taken, insufficient funds again. And then there were 2 warrants out of California, both again for theft. Further, once I had gotten the reports from California to see what those were for, one was for work that had been done on a Hummer, which he never ended up paying the bill. And then the other was for an RV that he gave $20,000, came back again as not sufficient funds. And then he was supposed to owe $85,000 on the RV, which he never paid, and the RV ended up in Florida where it was retrieved.
Okay, so all 5 of those warrants that were active either had something to do with theft, whether it's theft of money, theft of vehicles, or theft of vehicle trailers. Is that fair?
Absolutely, correct.
Okay. And I'm going to shift forward in time just a little bit. Let's go to July 7th, 2022. Were all of those warrants active on July 7th, 2022?
Yes, they were.
Okay. Now we're going to go back in time a little bit.
Okay.
Let's talk about the vehicles that you saw in the driveway at the Pine Grove residence. What vehicles did you see there?
There was a Bentley, regular car, the Bentley, 2 Harley Davidsons, and an ambulance.
Okay.
So there were 2 Harley Davidsons for that act. So maybe, it could have been either or that he met when he met Sonia. We don't really know. We don't know which ones. So yeah, I think independently, I agree with I would have to agree thus far with the information that I have. Again, this is just my opinion with what's out here with Woot, and that he does have some independent information. Now again, the stuff with the CP charges, and that might be why Winfrey is sitting there, because this would definitely affect her case if this is how the judge will rule. But again, if the judge rules against him, Woot may not care, because he said, I'll stipulate because I don't need nothing that was the fruit of the poisonous tree. So he was saying he'll stipulate because he's independently talked to all these witnesses. So he doesn't care. Now, when it comes to any other cases like what Winfrey has, that may be a problem for the CP charges specifically. But all right, y'all, we've been on here for 3 hours. Thank you guys so much for all of the love. Let me see. I appreciate it, y'all, and hanging out with you, girl. I'll probably try to upload in the membership just the entire video, if you guys want to just go back for your own research and cross reference and listen to phone calls and all of that. But shout out to Hoover. You know, he did his thing yesterday. I'm sorry y'all missed it. You know that I wasn't able to attend, but it's just like we were there by watching this video. So you guys have show out with the super chats and the cash apps. Thank you so much for all the support. You guys make me want to keep on keeping on. You know, sometimes the stuff gets a little hard. Sherman, thank you for the cash app. April, Snack, and S. Anaya, thank you so much for the cash apps. I appreciate that. And for all the people that gave the super chats, I had 3 different goals. I did one for 10 super chats. We hit that. I did one for 5. We hit that. Then I did another one for 5. So thank you guys so much for the super chats. And before we even got to the goals, because that was the first time I ever did that, I just saw it on my phone, so I wanted to see what it was. Before we did that, we had a ton of super chats already. So I thank you guys so much for the support. I know it is the holiday, and the fact that you guys are sharing your hard-earned money with me, I so appreciate it. Make sure you guys hit this like button, subscribe to the channel. Do y'all got anything else? Any other questions that I may be able to answer real quick before I get off? Thank you. Thank you so much again for all of the love. Said prayers up for the women in this chat facing the possibility of her government job being shut down in 2025. Also, the port negotiations are failing and could possibly see a strike January 15th. Champion said to Google it. That's right. When you guys say your prayers, now I lay me down to sleep and all of that, praying for your soul to keep. Make sure you keep the women and the men in government that are facing the possibility of shutdown down to anybody else, because we got enough going on that happened in 2024 because of Cat Williams. You know what I'm saying? He started a lot of this domino effect. So we need him to do an in and out so maybe we can have a better year. But let me say this. Yeah, he's the one that, you know, a lot of this stuff that has happened. So we're praying for a better year in 2025 for a whole lot of people. I did have some more. I'm sure there'll be more updates coming in on Diddy. As always, when it comes to this case, what's going to happen next is that the judge has ordered basically the state to respond to all these other warrants that he talked about, because that was outside of the scope of Hoover's motion. So he's going to be able to respond to that. Hoover has to actually list all the evidence that he's saying that should be suppressed, assuming that the judge is going to say, hey, you should have never taken the truck in the first place. You had no probable cause for it. So there's that. And oh, okay. Them folks said they already have a date in January for him to return, so Cat can curse folks again. Listen, I remember where I was when he did the interview. We were in Texas and we had to drive from like Houston to Austin or something. And so I was like, oh man, Cat Williams did an interview with Shannon. I was like, let's listen to it. And it took us all the way for the whole trip. It was no joke. Traveling Tootie said, can you please answer why the truck is not probable cause if it was going to and from the house and he was in it? That's not probable cause. Him driving in the car, they didn't say he broke any laws. They established that. He didn't run a light. He was pulled over that had nothing to do with the vehicle at all. He was pulled over because there was an active warrant for his arrest. That's why he was pulled over, to be arrested. But there was nothing that had to do with the actual vehicle. There was no information that she testified to that somebody said there's documents and he kept them in the back seat. I saw them. You know, it wasn't anything like that that was connected that they had probable cause to search. That is totally different. They had a warrant to arrest. Okay, so obviously there was probable cause for his arrest. And they're not, you know, he's not arguing that the arrest warrant was invalid. He's arguing that once he was arrested, you guys could have just went and basically got his car. So what it looks like based on the body cam, now that I'm kind of rethinking this, it looks like she probably was going to allow him to call someone to come pick that truck up. And then once she only testified that she seen some stuff in there or whatever, and she somewhat had a hunch, but she didn't know if it was evidence or not evidence that was in there. But once she got it to the police station and she went to go get the medication out the car, it seems like she saw stuff then when she opened the vehicle, and then she was making those statements, oh, we definitely got to get a search warrant. So it makes it for that, and then she added the house. So what it makes it appear like, what it makes it seem like, regardless of whether she had regardless, that she didn't think she had probable cause till she seen what was in that truck. So that means that when she got the went and tried to get the warrant for the homes and all of that, even though I don't think anything came from the homes, they said it was like empty or something. I don't even know if anything came from them. But when it actually came to the homes, she wasn't thinking about that till she looked at that truck, which they should have never gotten and told in the first place. He should have been able to call someone to come get it because there was no information that there was a crime related to that vehicle. So you just don't have the right to take the vehicle and do what you want to do with the vehicle just because you arrested somebody on a warrant that's unrelated. It doesn't have anything to do with you taking a vehicle unless you smell some type of drug. That's why in the beginning he established, like, you didn't smell drugs in the car. You didn't smell drugs on him. Wasn't no marijuana smells. You didn't look and see this. You didn't see that. You didn't see that. He wasn't obstructing traffic. You didn't pull him over because he ran a red light. Like, none of your investigation had to really do with this truck. So how are you trying to say you had it for an investigatory hold when none of your investigation had to do with this truck? That's really what the argument was. And I think he put his argument out there, and I think he did a good job at it. You said Erica's going to tell, well, her version, Patty. Erica's going to tell her version of what she's saying happened. Yeah, I haven't seen the affidavits for the search warrants, and that wasn't brought up that I saw in here. I mean, they gave it to her to look at and to enter as exhibit 1 of the prosecution. They did enter in the affidavit for the search warrant, but I don't know exactly all the contents of it, so I can't really speak to that. August lady said, but she didn't search it right away. The investigatory hold was necessary. And see, I don't. Also, it was very interesting because Wooten was up there. She made a statement of he only had one set of keys. It seemed like he was the only one with the keys. We had no information that anybody else had another set of keys. But then on cross-examination, she throws out there, and I think it was her nerves because she realized, okay, she may have said something that may affect this case. She tried to say, oh, it could have been another set of keys, which means we had to get the car to preserve evidence because it may or may not have been evidence in this car. And we've heard phone calls of his son and his friend Lamont, and I told him, and he told them in these phone calls, you need to go and get my stuff out of my car in these phone calls. So they could have came and they could have basically messed everything up by coming in and taking evidence. But the problem with that was, again, based on your testimony, you had no reason to really believe probable cause that he had evidence in that vehicle. You really didn't. You said it was a hunch. It may or may, as the judge said it, you may or may not have, and that was coming out in the testimony. But again, she has testified a little bit differently than what she did in the preliminary examination. Because in the preliminary examination, she made it seem like people had advised her that he keeps his paperwork with him in a backpack or in the vehicle. And that this was a vehicle that, even though it was in Shirley Strawberry's name, because in the first preliminary examination where she testified, she basically was saying that they didn't cause, because that attorney, Hannah, was basically pounding in and hammering in that you didn't try to call Shirley Strawberry. You knew this was her vehicle. Why didn't you call her? And her response was, and maybe that's why she responded the way that she did in the preliminary examination, because this question was imposed by Wooten. But her response was, well, I didn't call her because I was aware that this is, even though it's in his name and in her name, he's basically a constructive owner because he drives it all the time. And there's phone calls that actually corroborate she didn't want to drive the car. She didn't drive the car. He had just bought her a new Benz truck. So it was in her name, but he was the one that had control over this vehicle. And she testified that she knew that he kept paperwork and stuff in that car because somebody had told her that when she was doing her investigations prior to, for the last 30 days, that he kept some of his documents in the car. She didn't testify to that, which may have helped her a little bit for this hearing. But the calls were after the search warrant, correct? I have no clue. I would assume he wouldn't be mentioning about the car until after he was already arrested. So I guess that would be an assumption we can make, that any calls with Lamont and Dion would have been after he was already arrested. But I guess her argument was it still is proof that he was basically alluding on these phone calls that it was things in the vehicle. But you should have never had the vehicle because you didn't have no reason to take it and impound it, is basically what the original argument is. So any warrants or anything you got out of this truck and any warrants you got to look in any items related to this truck should be suppressed because you should have never had my truck in the first place. Them folks said she didn't really seem to prep for this hearing. I agree with others that she underestimated Hoover. Yes, she may have. Hoover did his thing. He does, from my understanding. I mean, I looked up the cases when he had the conflict. He does a lot of criminal obviously, but he does a lot of high felony, like death penalty cases as well. So he does like unaliving cases. He's not new to this. You know, he's not new to this. I didn't see too many theft related stuff. You know, they may have put him on it because it was considered on semi high profile because of Shirley Strawberry. But all the cases I saw, he was doing unaliving cases and I think gang related cases. So he's used to tough cases. So this is like probably just a thorn in his side dealing with a bunch of financial crimes. You know, so yeah, this is Mr. Big Play Bray. Yes, this is what we call an evidentiary hearing. It's a motion to suppress hearing, basically. So he was trying to suppress the warrant, the search of the vehicle. Jam said he gets credit for this for sure. Yeah. GC said she was too aggressive. No, I told you, if you didn't hear my spiel earlier, this is not uncommon for officers. Like they're more, or detectives rather. I think regular on the beat police officers, they don't care. They just say what their investigation was, what it turned out. They're usually respectful, like the ones that I've encountered. But when it comes to detectives, they put their heart and soul into a lot of it. And they do get invested. They talk to the victims. They talk to the families, you know, and all of that. And they don't really care for defense attorneys because your job is to defend your client. And they feel like your client is undefendable. Why are you even defending them? And it tends to show out during cross-examination. It'll show up in their demeanor, their facial expressions, their attitudes, and their tones. Yeah, they take it more. The key time frame is what made the tow to the police station, who said hold it for investigation. Yeah, and it seemed like that person who allegedly ordered it, who was the detective, because mind you, at this time, the Detective Fields was not a detective. She was just a beat officer. That was it. So she made detective though that January. So Earnest was arrested in July. We know it was a big thing in October where they did the whole he was on TV in October. We heard that on the calls, and also saw the news that talked about it, and they were trying to get more alleged victims to call the number. And then January, she became detective. So perhaps they felt like her surveillancing, and then it turned out to be such a big case. It probably did help her to elevate. And Roswell is a small community, but you got to look at it. Do they have this type of stuff going on in Roswell? Probably not. She talked about how it's an affluent area. And now you're looking at this long, ridiculous indictment that came out of this. So it probably did help her career somewhat. He may not have been embellishing that much when it comes to whether this may have helped her career. It probably did. Luke and Leah 15 said, if you know the justice system is crooked, or if you believe they are crooked, it seems like you would do all that you can to prevent yourself from falling into their hands. He does just the opposite. Okay. All right. All minds clear. We've been here for a minute, y'all. Shoot. 3.5 hours. I think I answered all of the questions that I saw. I didn't see any in the super chat. But, you know, he needs to, on any phone calls, he need to be saying he think his attorney did well, because it sounded like the judge was trying to lean in his favor, you know. Sounds like he might get somewhat of a W. What he will be charged with, what he's already charged with in his indictment. Let me see. So he has, the biggest one obviously is the RICO. Let me see. This is his indictment. So he's charged with RICO, false swearing, filing false documents, bigamy, theft by taking, conspiracy to commit unauthorized practice of law. So that's all the stuff that had to do with Erica King. And again, to me, it sounds like they have the Zoom videos of that. Filing false documents, identity fraud, filing false documents, identity fraud, theft by taking, conspiracy to commit unauthorized practice of law, false statements and writings. Is this his? Yeah. Let me see. Yeah, it's like 39 counts. Let me see something here. So the first one sounds like they're talking about someone named Drusilla Scott. So I think that was one of the warrants that was there before. So they talked about, this is a part of the RICO. Drusilla Scott. There was a Jasmine. See, some of these people sound like it was a part of them running those plates. Something about remodeling a home. There was another one named Crystal, where she was unlawfully taking money. Theft by deception for, who was this for? I think it has on here. Oh, this was the bigamy. I mean, that kind of is what it is. They got the license and all of that stuff with Shirley Strawberry. Theft by deception with something in Kentucky. So some of this, it just depends on if it came from that original warrant or not. So basically, these are all the acts for the alleged RICO, and then he also was charged with them individually. So you have the issues with the identity fraud, the conspiracies, because of the whole having Erica King represent them in these cases. So this is the indictment. We haven't looked at this in a long time. So there were 57 acts, overt acts, and then they went for count 2. They start with basically individualizing them, and I guess trying to charge him for the individual acts as well as separate just crimes in addition to the RICO. He said, and none of that got to do with a truck. All right, y'all. Let me get it. I can be on here all day talking with you guys. I hope you guys enjoyed the content. Make sure you like the video, subscribe, and until we got something else going on, I'll holler at you guys next time. Again, thank you for all of the love. I am overwhelmed with all of the support. I so appreciate it. Thank you so much. I'll talk to you. Oh, wait a minute. We haven't done Nesto in a minute. I mean, we haven't done Dre since we're talking about
and another thing you notice, the first thing they say, make sure you guys hit that like and the subscribe button. That's what it's all about. After they get through dogging you out, before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
Dre, we need you to come holler at us now. You become part of the Intellect family. We need you to come and to talk to us and let us know how you're doing. We ain't gonna get all in your business like that where you still driving trucks. Did you get your toilet fixed in the basement that was flooding your basement? Are you still talking to your buddy? Are you still gonna help him with this bond? We just want to know. We want to know. That's another thing too. I'm surprised that he hasn't tried to do the bond thing again. We haven't even heard anything related to it because I think I guess he had this RICO situation, so they probably, okay, never mind, scratch all that. All right, y'all, before I start going down another rabbit hole, I'm going to talk to you guys next time.